43.
Another side, who's there? What is this?
This is a pension matter, Lordship.
Which way are you joining pension matter?
We are yet to procure some information documents.
Otherwise, no objection.
Yes, Your Lordship.
Oblige, Your Lordship.
Hello, right.
It is Lordship. Lordship, I beg to mention item number 34. 34. This pertains to Akung matter, my lord. It's no more.
Yes, Mr. D.
I have no objection, my lord.
Yes.
I have similar prayer for item number 32, my lord, where I was directed to produce the record, my lord. I'm yet to receive the record, and I have informed my friend.
Correction.
Yes, my lord. Let it come also after 2 weeks, my lord.
Yes, for 2 weeks time allowed to the
Item number 35 also. This is also not my matter.
Honor to Mr. SD, counsel for correspondence also to produce records. Yes. And 35
35 also, my lord.
records.
No, not record, my lord. Not my matter.
He will have objection.
I don't think so.
It is for the respondent to bring the case to record, Your Lordship.
Sir, I have not received it.
Same order. 2 weeks for this. Yes.
My lord.
Bishop, I'm praying for some accommodation for item 48. My lord, after 2 weeks.
What's the matter about?
This is regarding
Compensation?
no
Or
compensation matter.
Yes, Mr. Harwala.
No objections, madam. AG is here, madam.
48, my lord. It's item 48.
Yes.
Only the interim order may continue.
Mr. Order continues.
Oblige.
Reversal of compensation is held up, my lord, and there were large number of the persons who have not been made party, and interim order is continuing, my lord. So
Then you file for vacating it. You have not filed. If there's urgency, you file an application.
my lord, this is for hearing. So if the matter is heard next week or so, I'm just not saying opposing today, my lord. It should be heard.
After 1 week.
After a week.
No, 1 week. Okay.
Oblige.
Please, Your Lordship. Lordship, I beg to mention item 39.
May I 39?
I'm for the
39.
state, Lordship. I'm for the state, no?
Yeah, objection.
No.
What is the matter about?
It's dispute between two wives, my lord.
Pension.
Dispute pensionary.
Yes.
Oblige.
Supplementary list item number 1.
Please, my lord. I have come before this honorable court today being aggrieved that the principle of natural justice was never practiced by respondent number 3, 4 and number 7. Now the brief facts of the case is that I have a huge plot of land. It stretches over 3 villages. Now, out of those 3,
You're the individual owner
Yes.
of all these lands.
yes. So
That is undisputed.
yes, well.
Okay. Yes.
Now the brief facts is I have a huge plot of land. It stretches over 3 villages. Now out of those 3, 2 villages acknowledge my ownership. Only this one particular village, which is respondent number 7, never did so, and also we never have any knowledge.
So you have villages within your land.
Yes. Now this respondent number 7 is a recently formed village. Now we have no knowledge when it was formed because there was no public notification. It was notified, which is mandatory as per the Ilaka Act 1991. Now I have no objections regarding the alteration and formation of the village, but that should not deprive me of my right to be heard, because as per the letter in can you see page number 24, my lords?
Where is that?
24 page.
24?
Yes, 24. I like to number 3. If I may read. Now by this letter, this resolution of the Dorbar of Sokarbam Rim village held in so and so have unanimously resolved to inform you that you shall have no rights to claim ownership over your land lying and situated under the jurisdiction of the village.
But looks like a civil dispute.
Yes, sir. Now I could not even.
Now one thing, is it Mr. Lingdo, right?
Yes.
Is it the creation of a new village, or is it bifurcation? Was it realignment? What is it?
Was newly formed. We were never notified of that.
And this Sokarbam village is a new village.
Yes, yes, yes. let's talk about RIM, which is respondent number 7. Firstly, it was on my land was under jurisdiction and administration of respondent number 5 and 6. Now, respondent number 7 was newly formed.
So you see, when the new village created,
yes,
the 5 and 6 were heard.
Yes,
that is your
5 and 6 acknowledged my ownership.
No, were they heard when the new village was created?
Yes, my lords.
They were broken off from the parent village.
That was a long time back. Yes, my lords. I have no objection regarding that, my lords, but since I cannot place my case.
Yes.
May it please your lordship. Your lordship, first and foremost, your lordship, the letter clearly stated, your lordship, that you cannot claim ownership. This is, as your lordship had pointed out, this is clearly a civil dispute, your lordship. Secondly, they have not challenged any of the order of the district council or either of the aim of Hima Nongklau, your lordship. And even if it is the case of formation of a new village, your lordship, as per the Ilaka Act, section 4, your lordship, if they have any objection or anything against that, your lordship, they have recourse under the Act, your lordship, to file an appeal before the executive committee or before this aim at the first instance. That has not been done, your lordship.
We were never notified, my lords.
Lordship, can I obtain a copy from the office of this aim, your lordship? That is not an issue here.
Notice for now. Mr. Arlindo, then Council the Petitioner, issue notice. MSPS Nongri is present, except for we have responded 1 and 2. No further notice on these respondents. At this stage, no notice yet to the current respondents. Stop. Notice court reservations about detailing the petition due to the nature of dispute in question. However, as it involves the creation of a new village, MSP Nongri to produce any records that were relevant.
Your lordship, I'll seek instruction. There's nothing with us, your lordship.
Seek instruction to produce any records.
All right,
maybe 1 week. 1 week.
Can you produce in 1 week? After
I can, your lordship, but can he take steps in 1 week?
No, only for you.
All right, your lordship. I've been.
After we see what orders were passed, then we might.
I've been informed, your lordship. There's nothing in the office.
At the stage also. Okay, yeah.
All right.
After 1 week, yes.
Item number 2.
Lordship, please, your lordship. Lordship, perhaps your lordship cannot take up this matter, your lordship.
Why?
Respondent number 5 has been represented by your lordship, your lord.
Why?
This is Langren Matter.
Respondent number 5, your lordship, has
challenging
been
the reinstatement of the chief.
Challenging of
reinstatement, yes. Highly obliged, lordship.
Langren Matter is still alive.
Challenging the reinstatement now, your lordship.
3.
Please, Lordship. Lordship, this pertains to non-payment of compensation for the building which has been dismantled by the National Highway Authority for construction of National Highway from Tura to Dalu. Now, this what happened actually, the land has been acquired. That I am not disputing and I am not claiming for the land, but attached with the land, the building was constructed and they are not disputing. That building
you
was.
mean to say there is no assessment for your building?
They have not assessed
How
my
is that
building.
possible? Demolished now?
They demolished this
How will you
dismantled
assess it now?
because we have even the pilot representatives where they have admitted also they.
Okay, just tell the court. So there was this land acquisition or requisition proceeding, correct?
Yes, Lordship.
Tura Dalu Road.
Lordship.
Now your building's the side of the road.
Yes.
Your land is acquired.
Land is
Will you
acquired.
pay, compensation.
The
for
land is Nokma's land because that is not my belongs to my land. It is not my land.
Oh, so Nokma has taken the compensation.
Nokma has taken the compensation, but for the building I have not paid.
No, how do you know not been paid?
Because in the representation they have actually the National Highway have directed for the Deputy Commissioner to assess and for joint inspection. It is their lordship, and that they are supposed to lordship. There is a letter. Yes. They said that they will conduct the joint inspection. Where I see the page 44, the relevant annexure 10, my lord, where they have clearly stated that this has not been done actually. See, this is the issue by the additional Deputy Commissioner, Revenue, West Garo Hills, Tura. May I read the relevant part? Actually, they said that they will be conducting the joint inspection.
Complaint is non-payment of compensation of wine shop and RCC building.
Yes. So they said that hereby declare to cause joint inquiry with an officer of NHDCL and
What happened
PWD
after
building.
this?
After that, there is no outcome.
Only 7 July, it's not even 1 month, they give us order.
No, actually, not 7 July.
It comes so quickly.
No, actually, prior to that also we have written a letter. Actually,
No, even
we have
then,
been pursuing since from the month of March.
7 July 2026, the Deputy Commissioner, whatever, the revenue, he has directed the 45 plot to be examined again. So,
Yes, now
premature.
not
We haven't
premature.
done anything for 1 year, we can understand. Now, not which 1 month has gone and now you've come.
One month prior to that also they were pursuing from the month of
Prior to that doesn't matter.
April.
Prior to that, it's culminated in the detailed inquiry which has to be gone. What to do?
At least let them respond to that because
How will they respond? Take down her.
May I submit, my
Yes.
lord, two things, my lord. The suppression of material facts, my lord. Kindly see paragraph 9 of the writ petition.
Yes. Oh,
Paragraph 9 had been dismantled. His wine shop had been unoperational till 2019 and respondent authorities acquired the land and dismantled. So it is a case of 2019, my lord. And kindly see one more letter, my lord, page 42. Paragraph page 42, letter of the National Highway Infrastructure Development, my lord. This is a letter of 20th April.
okay.
And in
Okay.
respect to this complaint only, my lord, paragraph 2, may I place that, my lord? Reference is invited to letter received from Jitarsan A. Sangma, resident of so-and-so, wherein it is mentioned that number so-and-so was dismantled in 2024. Now his case here before, my lord, in the 24. For the stretch of National Highway road so-and-so, no compensation has been received and provided for dismantled structure. 2, my lord, very important. In this regard, the submitted application was duly scrutinized based on the available documentation. It has been observed that beneficiary name is not included in the list prepared under section 11, 19 and apportionment list of NHIDCL by Skala District Administration. These lists were prepared following a joint survey conducted by all stakeholders, and based on these submissions, compensation amount was deposited by competent authority of NHIDCL. Further, it is to be noted that dismantling was carried out in the presence of magistrate for structure for which compensation has already been paid, as well as those structures within the right of way after section 11. In view of this, requested to review the application suggested by. So, my lord, this is the fact.
This is 24, 26, yes.
Yes, my lord, and this is the so.
We are disputing because the fact is that fact remain the same that we have been operating our wine shop. The dismantling take place in the year of 2010. They have not listed their admitting.
One second. This dismantled in the year 2024, correct?
Lordship.
Your name not in the
19,
list. No, 24 is
19.
dismantled. No. Now, as per the letter, dismantled 24, you stop operating in 2019. So what did 19 to 24?
Because the moment they acquired the land, before this, they don't allow us to operate that is what I mean to say.
No, one thing, Mr. Sangma, you have to understand. We can understand if you have not been paid and you listed as beneficiary for the structures.
Yes.
The normal course is that if land's acquired, if there's structures there, that's assessed and you're paid. So the compensation's already been paid. So who took the compensation?
No,
Mr. Nokma has taken a compensation, correct?
No.
Don't ask from Nokma.
Nokma is a land of the owner. He said that he has received only for the land. My argument is that let respondent so that they have paid the money for the building also. That is not there.
I said here, see, the list was prepared for a joint survey conducted with all stakeholders, and based on the compensation amount is deposited by the competent authority of HSC.
Lordship, I'm even disputing this letter because they have again, Lordship, kindly appreciated the page. Then they said they will conduct the joint inspection. If that is the if they're relying on the dated 24, 26, then they should not have any inquiry.
Futile exercise.
No, it's not a
structure. I don't.
See, Lordship, I have even enclosed my wine shop also. There is a license. I am since from 2019.
The building. Sure.
That I can bring, Your Lordship, but I did not enclose.
You don't take photo of some other building.
No. It is there. Even now, it remained. The building was there, Your Lordship.
Just trying.
Not trying, Your Lordship. Kindly see my I was operating even the wine shop also.
Yes,
See the.
Take down, yes, heard the petition, Sangma, the constable for the petitioner. The grievance of the writ petitioner, it appears is the non-payment assessment and payment compensation for an RCC building and wine shop, which it is submitted, has been operated by the petitioner since 2010-2019. So, it is further submitted by the Learned Council that the persons approach this court in view of the fact that though an order has been passed for detailed joint inquiry by the Office of the Additional Deputy Commissioner of Revenue on 7 July 2026, no action has been taken in this regard. Next paragraph, Mr. Attorney General appearing for the respondents has submitted that the petitioner in fact has no case in as much as apart from the building being apart from the said building or wine store not being operative in 2019 in the NHIDCL, that is by the NHIDCL in a letter dated 24/2026 have clearly stated the exact situation. Learned Attorney General has referred to the letter and has submitted that as per the letter, the petitioner is not listed as a beneficiary or included in the list prepared under section 11 and 19, and that a joint survey conducted and compensation amount was deposited by the Competent Authority NCCL. Therefore, submit that nothing remains for consideration with petition, and the same shall be entertained.
Lordship, one more.
Yes.
Till now, I am paying the renewal pay for my wine store. That annexure page 40.
Where you have wine
because though my building was already dismantled.
Then have you filed representation to excise?
No,
your license to be suspended at time being. How can you ask for that?
But Lordship, that is a different issue, my lord. Because
then don't bring it up.
But now here is because that wine store, the building, to show that building exists in that national highway, they have dismantled. They are just denied.
You listen to the order. Yes. Start no. M first, not beginning. Yes. So this court notes that there is no necessity for on these submissions as made. This petition will be disposed at the motion stage itself. The presence of the Attorney General with the message for 1, 2, 3, 1, 2, 4 is noted. Also, the presence of where is Dr. El Musica?
He's currently on next.
He's out of station.
He's currently on next.
And presence of MSC Jala for
Respondent 5 much.
Respondent 5, and what about 6?
6 I have no instruction.
6 by Dr. Musica is also noted. Notice it appears not necessary at this stage to other respondents 6 and 7. Next paragraph. On hearing the counsel of parties and an examination of the materials as placed, it is noted that though the NHIDCL by the letter dated 24/2026 had categorically stated that the petitioner is not in the list of beneficiaries and that compensation would be deposited and paid for the land and buildings acquired However, in view of the letter dated 7 July 2026, wherein a joint inquiry is to be conducted, so this court does not deem it fit to pass any orders at this stage. The petition is closed, yes, and disposed of. We are putting one store now in the jungle. You read your license.
No, we are not operating, but because we are, I am asked to pay.
Yes.
Right.
Yes. Who is there for this matter? Mr. MSS.
Yes, Your Lordship. Your Lordship, this matter was referred to the for mediation, of which the matter was settled. They've agreed to regularize and subsequently disperse the pension.
When was the thing held?
The last was on 22nd, if I'm not mistaken.
Yes, the
21st.
It's
21st.
that the mediation proceeding have been successful
20th.
and settlement that we've arrived at in the parties. The same has been placed for this court. So accordingly, this matter is disposed of on being settled by settlement deed dated 21/8/2026. So the said settlement deed shall form part of the order of this court.
Right.
Yes.
Highly obliged, Your Lordship.
All right.
Daily list item number 1.
Please, Your Lordship. Lordship, I pray this matter if it come up after 2 weeks, Your Lordship.
Why?
Since the conducting counsel AR Pasa is out of station.
This is also regarding that land acquisition. Money has already been paid.
Saying that why they've come by it. That's the only thing they have to.
That's the only thing they have to
establish the court, establish the case.
Yes. So after 2 weeks, Your
Why
Lordship.
not 6? 2 weeks. Yes. Yes. It's fixed admission hearing today.
Yes.
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 Yes, ma'am.
On the prayer of the counsel, the petitioner due to the absence of arguing counsel, this is a matter of 2 or 3 weeks.
2 weeks, Your Lordship.
2 weeks.
Obliged, Your Lordship.
Item number 2.
Lordship, this matter is fixed for appearance of the respondent number 7.
This item, my lord, I received a letter from the headmaster of the school, since it's a government LP school, my lord. They've requested me to appear in this matter, my lord.
1 second. 6 has refused.
Yes, Lordship.
1 second.
Jonkipara. Number 6 is the headmaster, my lord.
Why he refused service?
But I have received a letter, my lord, saying, requesting me to, yes, requesting me to appear in this matter, my lord.
Mr. Paske appealing for whom?
Mr. Pasi is appealing for respondent number 8.
And 7?
It's fixed for appearance of respondent number 7 today, Lordship.
This is Jonkipara, my lord.
This is a
7 is Buldangre.
headmaster. You are appealing for him also?
No, my lord.
Sub, Mr. Kivi Barasaji submits this Daring Grey case. You appear in this.
This is Jonkipara, my lord.
Jonkipara, okay. He refused. Mr. Kivi Barasaji today has entered appearance on behalf of the respondent number 6, though as noted by this court in order dated 10/8/2026, respondent 6 refused service. This was the counsel. Mr. He submits that this was because the respondent number 6 has requested him to appear
since it's a government
since the school, the government school stuff. Accordingly, the presence of the appearance of for respondent number 6 is also recorded. None appears on behalf of number 7 today. Yes, what you want to file affidavit?
Yes, my lord. I will.
When?
At least I'll pray for 2 weeks for that.
And Mr. Paski, you file?
I've already filed, Your Lordship.
Yes, Mr. Masuluya.
No objection, Your Lordship.
No, not objection.
Let him file his
Sir, rejoinder to
I'll be filing my rejoinder if it's required, Your Lordship.
Yes, sir. Just after 2 weeks for appearance of affidavit by respondent 1 to 5 and 6. Yes. Next day we'll file, we'll pass orders on 7. He doesn't appear. Or have they received? You sure?
No, Your Lordship.
They have received notice 7, correct?
Yes, Your Lordship.
3.
May I please, Lordship? My Lord, the contempt petition against the order dated 18th March 2025, my Lord, related to the clerical trade of Assam Rifle, my Lord. SLP and review petition has already been dismissed, my Lord. And the last occasion, my Lord, has directed to the respondent to take instruction for regarding the implementation, my Lord.
Just give some more time, my Lord.
How many petitions here? 606.
My Lord, 611, my Lord.
In fact, there are another matter, my Lord. There are also another 500 petitions. The financial implications are very huge, my Lord.
My Lord, by financial implication on that ground, my Lord, the contempt cannot be delayed, my Lord.
Some more time, my Lord. Implication may run to few hundred crore.
As the amount of personnel involved is huge, it was a praise allowed 2 weeks for that time to file affidavit. Yes. Praise allowed.
My humble prayer before your Lordship as a last chance may be given, my Lord.
That has no meaning unless it goes through too many layers.
My Lord.
Or
Even if you make them appear here also, send them to jail also, you won't get your relief.
My Lord.
Not to make observation, but yes.
My humble prayer, my Lord, the matter is under active consideration. So
That's what you said last time.
Yes, my Lord. So I'll pray for a little more.
File affidavit.
My Lord.
You already filed affidavit?
Already filed, my Lord. If required, I'll file another one.
There is a clear direction, Lordship, to comply with the order of the this court, Your Lordship.
Why is not appeared? Why?
My Lord, this is pending before the cabinet will have to consider.
How long it can be? Because we have sufficient time
This
has
is
been
not
given,
just
my Lord.
petitioner, my Lord. There are several others.
There is sufficient, but on the last, Your Lordship has observed, because there's preference should be given to, because there is a court order, my Lord, because it's amount to.
My Lord, there are court orders even with regard to some of the others who are on the
But the other party, they don't approach for filing the contempt. But here is a clear, because
This is one 19/5/2025. Yes, the order of this court is dated 19/5/2025. Today again, Mr. Q. Varasaji has submitted that the matter is under active consideration and prays that more time be granted. This court has taken serious note of the lapse in complying the court order. So this is matter of 3 weeks, in which let the who's appear, the contender number 1 to appear in person.
Lordship.
Yes.
What's the rest, Lordship?
5.
Bill has been placed for consideration, my Lord. Draft bill.
Any development?
My Lord, I am informed that it has been referred to the Honorable High Court for consultation or advice, my Lord, because it is a issue relating to creation of.
It have to go to the full court.
Yes, my Lord, it has to go to the full court.
Yes, the list after business. We'll post after 3 weeks then.
Lordship.
Yes, ma'am. Yes, ma'am.
As a matter, as just right there on the prayer of the parties, the matters pending consideration. This after 3 weeks, yes.
Item 6 is connected. Connected.
Together.
7.
Please, Your Lordship. Your Lordship, I raise the objection with regard to the legality of the marriage, Your Lordship. So, the ground that the marriage was dissolved through customary practice, Your Lordship. So, for Lordship, I seek some instruction from my client, Your Lordship. I need some more time to give the proper.
You are paying for respondent number
5 and 6, Your Lordship.
My lord, I humbly object, my lord. They have been given ample time to bring whatever they need to bring on record, my lord. If your lordship would have the order, she's, my lord. It has been seen ample enough. They entered
since the
in
matter
November.
is something, Your Lordship,
They
so I
entered
want
in
to
November, my
satisfy the
lord.
Lordship.
Yes.
They entered in November, sought for time almost 5 times to bring whatever they could on record, and this is the best that it could, my lord. Where they bring documents which have been produced after the filing of this case also, my lord. And today they will be
After
given
the
another chance.
Lordship, earlier,
They'll be given another chance
there
to
was
bring.
no case, Your Lordship. To prove my case, definitely I'll bring the document later on, Your Lordship. So now the question I raise here, Your Lordship, I need a thorough research on the point, Your Lordship. So I'll come and satisfy the Lordship.
My lord, in light of the
Just give me, Your
unsubstantiated
Lordship,
claims, my lord, the same cannot
just
be
2 weeks time, Your
considered,
Lordship.
my lord. She's a stranger in the entire relationship itself, my lord.
Yeah, I'm the stranger, Your Lordship, and even the petitioner, even the brother is a stranger in this case, Your Lordship. The biological brother of the, yes,
And
Your
the petitioner,
Lordship.
the wife, my lord.
The wife of the deceased employee.
Yes, the deceased brother also is a stranger here in this case, Your
Who's the
Lordship. as
brother?
well.
He's been a
Respondent
party.
number, yes, Your
Respondent number
Lordship.
6, my lord. He helped
why
her.
five?
He helped her to attain the death certificate.
He's
my
being a
lord.
biological brother. He just obtained the death certificate,
Lord,
Your
He's not
Lordship.
appeared.
My lord,
Yeah, I'm
through her only.
representing.
5 and 6.
Yes, Your
Yes,
Lordship.
my lord.
So just Lordship, if you kindly
Where's the
permit me 2
affidavit?
weeks. You have
Have you
submitted.
filed
it.
affidavit?
Yes, Your
Yes,
Lordship.
my lord.
I
Just
filed
have a
long
look at
time.
that.
Yes, sir.
My lord, the documents
Just
itself.
2 weeks time, Your Lordship.
Did,
One second.
Yes, sir.
Your name is Diana Dakhar or Diana Savian?
Diana Dakar, Your Lordship.
But you've been written this, but in the course.
But in the, yes, Your Lordship, that also, they have wrongly reflected my surname also, Your Lordship, in the death certificate. So I'm presenting this respondent number 5 and 6, Your Lordship, here.
no, the death certificate says Diana Savian. It's not my mistake, my lord. It's the respondent's mistake itself. If she
That I can
submitted the
clarify.
documents, then even
Yes,
the
Savian,
authority
right,
also.
Dakhar Savian, actually.
Yes, Your Lordship.
Their documents only, my lord.
Through my affidavit, I clarify that part also, Your Lordship. Just 2 weeks time, Your Lordship.
You're the second wife.
I'm the
No,
second
my
wife.
lord. They
Yes,
never
Your
got
Lordship.
married, my lord.
But I have
Even if you
cohabited for
but you
the
have-
long
but you
period
have
of time, Your
issues-
Lordship.
You
Yes.
have issues from this,
No
civil.
issues, Your Lordship.
No issues.
No, Lordship.
Lord, if she claims dissolution, my lord, we had gotten married under the Christian Marriage Act. The only way a dissolution would have to occur would be through the Christian Marriage Act alone itself. No customary practice of whatever conjecture they place before your lordship can be
You got
tolerated. my lord.
maintenance also?
No, no maintenance. Earlier, the first wife was claiming for the maintenance, not for herself, Your Lordship, for the 2 children, Your Lordship, which I
You
have
got
clearly
that?
mentioned. Yes,
My
Your
lord, that was
Only
we
for the
received
children.
till up to April 2025, my lord.
Then
Through the
after-
order of Masa, my lord. That's why we have
Yes,
received
Your
that, my lord.
And whereby she claimed, the petitioner claimed maintenance only for the children, Your Lordship, which I have mentioned
Yes,
in
my
my...
lord. Today we're not here claiming for maintenance, my lord. We're claiming
time
for
when he's alive.
pension, my lord. Yes, my lord.
Yes.
Right.
Yes,
After
my
he
lord.
expired, then
He
the
passed
maintenance
away
stopped.
in May 2025. The pension, the maintenance amount was received till April 2025, my lord.
No, he died, so.
Yes, my lord.
He said
So
he
we
was
are not here claiming for maintenance, my lord. We are here for pension, my lord.
We understand.
Yes, my lord.
That means he was cohabiting with her only.
Yes, Your Lordship.
Illicit affair, my lord.
Not illicit, Your Lordship,
That
which I
is
can prove,
beside
Your
the
Lordship,
point.
later.
But whether you do,
My lord,
you never
in-
married to him.
Nothing.
Not married
They
because
don't
of-
have any
Yes,
other
Your
document to
Lordship.
support this
The customary,
claim, my lord.
Lordship, customary practice, so I cannot
Conjecture, my lord.
give in writing, Your Lordship. There's
Conjecture, my
nothing
lord. It's
paper
all
in
conjecture,
writing.
my lord.
Okay. Yes. Let's give one opportunity.
Yes, Your Lordship.
My
The
lord,
last opportunity.
Urgency
Your
is
Lordship.
there, my lord. Petitioner suffering right now, my lord.
No
She has
urgency,
no home
Your
anymore,
Lordship.
my lord.
They have been
She does
living
not have a
separately
home.
for the last 14 years, Your Lordship.
She can't afford to have a
this,
home anymore now, my lord.
14 years.
MS E.D. Sharma prays that she will have further time to prepare the matter and to bring other materials on record necessary. Stop. Prayers aloud.
Pending, my lord,
Last
urgency.
chance, yes.
Highly
Is the matter on so further hearing?
Obliged, my lord.
No, you don't have anything.
My lord.
Yes, Your Lordship. I have a burial certificate. I can
My
prove
lord,
through the.
that also is
Your
produced
Lordship,
in February of 2026, my lord.
Yes, citation, Your
He died
Lordship.
in May 25 and they
Satisfied.
produced that in
Yes.
26, my lord.
Much obliged, sir.
Obliged, my lord.
Yes, last only. You withdraw this one.
No, Your Lordship. Your Lordship, I have the notification issued by the Executive Committee of the
renewed.
CDC extending the term of office of the office bearers, Your
Okay,
Lordship.
yes, should. The same people are still there.
Yes, Lordship.
You sure about that?
The term has been extended from time to time.
Okay. Yes. Though your name?
And Sangma, Your Lordship.
Yes. Though by order dated 12/8/2026, the counsel for the respondents 1, 4, and 5 had submitted that the term of the present Darbar Eleka Rambai expired on 5/7/2026. Today, Mr. Lasongria, Learned Conference has produced a notification dated 31/7/2026 showing that the said Darbar has been renewed for a further period of 1 year. In that view, the matter is not infructuous. Have you filed affidavits, all of you?
No, Lordship.
All have filed.
I filed.
You have filed your affidavit.
I'll file my rejoinder through the affidavits, Your
You
Lordship.
already filed.
They've already filed their
As the
affidavits.
matter ready for hearing, that means.
I'll be filing my rejoinder, Your Lordship, to the
Oh,
affidavits.
Purchase, Mr. Latsungri is allowed, the law counsel is allowed
2 weeks time, Lordship.
to file a joint affidavits filed by respondents number 4 and 5.
2 and 3 and 4 and 5, Lordship.
Yes. Copy of notification is 31/7/2026. Stay on record, made part of the stay on board, made part of the record. Yes.
Obliged, Your Lordship.
9.
Contempt.
No, my lord. 9 to 15, my lord.
Petition, my lord.
9 to 15, my lord.
9
Some
to 15, my lord, matters pertain to the selection and appointment in Assam Rifle, my lord. But till today, my lord, affidavit has not yet filed, my lord.
We'll file it, my lord. 2 weeks
Just
time.
file one truckload of affidavits, Dr. Mojika.
Daily I'm doing 2, 3, 4 affidavits, my lord.
You'll need more hands to help you, I think. Yes, Dr. Mojika, please follow for the to stand for affidavit. This also. Interim order, we need to continue.
My lord, deep your lordship.
Till next day.
16.
Please, Lordship. This matter, I'm appearing for the private respondent. Also, I have filed my rejoinder, affidavit in opposition, my lord. I also filed a miscase, my lord, to vacate the interim order dated 07/04/2026.
When did you file miscase?
It is listed. Actually, I have filed it. I have filed it this month of June. The date is not mentioned. This case is 199.
Month of June, you filed.
Yes. Now,
You corrected the defects.
yes, corrected defects.
6/7.
Yes.
Yes, Mr. What?
I'll need some
Your
time, my lord.
application is of the order.
Oh, filing show cause, my lord.
So, cause is
Because this matter actually could have been heard together, my lord.
see your application orders.
Actually, we are challenging the jurisdiction of the chief executive member, saying that he does not have the original jurisdiction, my lord. That's the entire crux of the matter.
Why don't have jurisdiction?
As per law, my lord, the settlement officer has the original jurisdiction, my lord.
Oh, it's a land matter.
Yes.
Okay. When was which date's interim order passed?
Lordship, the interim order passed on the 07/04/2026, my lord.
No.
In WPC 142 of 2026. These appeals are not.
07/04 option indicates one to be served. This is matter 27/4.
Yes.
Then.
Annexure 2.
What is the interim order?
No, this is the last part. In the order. In Miss case, WPC number 109 of 2000.
Miss case is there.
Yes, Miss case is there. Miss case. The Miss case.
Okay.
The relevant, but page 22 of my application I have enclosed.
Okay.
In fact, this matter could have been heard together, my lord, once
yes. Now my ground of my filing this the miscase application, I will rely on the page 42, the impugn order passed, the order passed by the CEM of JCDC, where he have said during the pendency of the I have another case pending before the EM court that challenging they're claiming that NOCMA, because as per that instruction there is only one NOCMA, my lord. But they're saying that this Akang is a joint NOCMA. Now in this particular case, what happened? Since they are claiming that this Akang is owned by the three NOCMA, joint NOCMA, so in that process, without I'm the first NOCMA, according to them, since I'm the first NOCMA without my knowledge, without my concern,
now okay, one thing. If we vacate this order, the whole matter can be heard, can be finished also.
Yes, can be finished, because it is.
No, my lord, they are actually what by virtue of this order, my lord, they're actually selling off the other properties as well.
No.
That is the reason why that matter is pending.
Kindly see, I wanted to draw attention before this court. The order passed.
You don't know. He was here earlier, right, sir?
He was here.
You're not filing affidavit.
They have not yet filed their affidavit, my lord.
Very important that affidavit be heard.
Yes.
Take down the miscase. Do this miscase number.
Miscase number 199, my lord.
Miscase 199. In this application for vacating the order dated 27.
Yes, lordship.
Order 0704.
07/04/2026.
Passed in miscase number 109/2026. For consideration the same, it appears that affidavit corresponding to the main case is necessary. In his view of the matter, the miscase shall be taken up together with the main case for final disposal. Expected that affidavit filed within 2 weeks.
Lordship.
1 and 2. You heard the court. Within 2 weeks you file it. Then it is after 2 weeks. Yes.
Okay. Meanwhile, it should be, my lord, the interim order should continue, my lord.
Of course, interim order will continue for the orders.
Lordship.
We dispose of it.
For the orders, sir.
Your lordship, the state has filed the affidavit. That's for the petitioners to file the.
You got agenda?
Rejoinder is not required.
Not required. Very good. Ms. Emma Marak submit the rejoinder required. Is it for hearing? Or you
Yes,
want to
lordship.
dispose it now?
I'm doing 2 weeks time, Lordship.
Okay. This for hearing after 2 weeks. Yes.
Much
Pleasure.
18.
My lord, in this case, we have received a reply, my lord, filed by the respondent, my lord. We can bring.
We are praying for some time, my lord, to file rejoinder, my lord, in this matter. 1 week time, we will be able to file. It is already drafted.
Armiase.
A colleague of ma'am.
Yes, Lordship, I will be on behalf of.
Who are you? You are Armiase.
Lordship, I'm appearing on behalf of Ms. K. Inatulisema for the sole respondent.
Have you corrected the defects?
Yes, Your Honor.
Yes, my lord. That too, we have received the correct copy, my lord.
Yes, sir. What is your name?
ZSL Simram, Your Lordship.
Yes. Record her name is Simram. submits that the defect has since been corrected as allowed by this court by order dated 01/07/2026. What do you want?
Lordship will bring some 1 week's time.
Yes, as prayed, 1 week's time for rejoinder to the petitioners. Yes, this thereafter.
Obligation.
I do that. 19.
Yes.
Lordship, will this wait for further 2 weeks' time, Your Lordship?
Why?
Lordship, the petitioner has
This is
expired, Lordship, so I need to file appropriate application for substitution, Lordship. I'll
It
file it.
survives.
Yes, Lordship.
It's a pension matter.
Pension matter.
When did he pass away?
1st of June this year, Lordship.
Without getting pension.
This is a case,
actually
Lordship.
this is a case of the non-teaching staff which were taken over the schools
That is the council.
by the
This is
district
council, yes,
council.
Then where's the other matters? Where's
Other matters,
My
Your
Lord,
Lordship.
the court, they are giving their pension to the
So we just
non-teaching
want to
staff.
place our affidavit on record, Your Lordship, and we can dispose it. But
Just
of
amend
course,
the
now that the petitioner has expired,
No, but he'll have to put on record this.
yes,
Mr.
I'll file it tomorrow,
S.A.
Lordship.
Sheikh submits that the petition since expired. He prays and is allowed to
necessary
to bring to partners to
substitute.
To file an application for substituting the legal heir, to substitute the legal heir in place of the petitioner. Stop. Next paragraph. MST Yang EB Leonard AAG with so and so. You want how much time?
2 weeks' time, Your
Yes,
Lordship.
without 2 weeks time to place to file affidavit. Similar prevailed by MSCB PASA for respondent number 8. Yes.
1 to 7, Your Lordship. I am for 1 to 7.
20.
Affidavit bring to some times.
This is which trade?
These are staff nurse and the Assam Rifles promotion matter.
That's trade 2 or 3 weeks?
3 weeks.
3 weeks for a time alone.
21.
Lordship, I'm appearing on behalf of respondent number 2. I
Number?
pray 2.
1 second. Defreezing?
Yes, Lordship. Your Lordship, I pray for 2 weeks' time for filing an affidavit.
Respondent number?
2, Your Lordship.
You are paying first time today?
Yes, Your Lordship.
First time?
Yes,
No,
sir.
NG Shilla for
Yes.
2 appeared last time.
Yes.
You have NG Shilla?
Yes, Your Lordship.
Yes, receive.
Number 1.
How much money you have in your account now?
78,000, Lordship. And Lordship, last month the salary has been credited on the same account, Lordship.
You have 20,000. Now, there were 2 transactions into your bank account. You're aware of that, no?
No, Lordship.
Yes, we'll give a copy of this one, totaling 74,000. So anyway, what is your name?
P. Roy. P. Roy.
P. Roy. MS P. Roy. Vice MS NG Shalla. Someone who's present. Stop. And today, Ms. S. Lalu has produced a status report dated 10th August 2026, wherein inquiries were conducted by officer in charge Rani Police Station from the concerned bank Stop. The status report taken on record. Stop. As per inquiry conducted, the information obtained from the concerned bank established the amount of 24,000 rupees has been placed on hold in the bank account in connection with the financial fraud complaint. Stop. Next paragraph. Your name, sorry?
T.A. Sangma, Lordship. T.A. Sangma.
Yes. MSDA Sangma for the petitioner submits that the account, however, is a salary account for which if she not be allowed to operate will put her into great hardship. And in view of the matter, it is directed that the respondent number 1, year 1 or 2 may keep lien on the bank on the amount 24,000 is disputed, and the account of the petitioner be defrozen. So, list after
2 weeks.
Affidavit, yes.
So bless Lordship.
Be defrozen immediately. Okay. Yes.
22.
The correct approval amounts for number 2 to defreeze immediately.
Source of affidavit.
Yes.
Bring some more time.
Yes.
3 weeks time for affidavit.
You'll have to file affidavit.
As paid for the 3 weeks time allowed. Is your case or Mr. Kumar's case?
This one is which
My lord, I am for item number 23, my lord.
Okay.
next item.
23.
Next item, my lord.
Yes.
Also, I'm praying for time. 3 weeks time.
303. Yes, for a 3.
Miss, my lord.
For a 3 weeks time allowed. Fresh matter. Yes.
My lord. Deeply, lord.
24.
Lordship, in this case, my lord, one miscellaneous application has been filed. And in that miscellaneous application, prayer is they want to make the payment in installment, my lord. If you lordship will see the miscellaneous application. So the main issue is not now they are not contesting the demand. What they are saying that they should be permitted to make the payment of 1,95,42,000 in 3 installment, my lord.
Yes,
Now, my lord,
yes, my lord.
One issue is there because our hands are tied, my lord. Problem is, if you lordship will see the notification of the government, that is there at page 48 of the petition.
Excuse me.
Page
48. And in this case, my lord, this is 2021 notification, where the government permitted payment of subject to 50%, my lord. But this was, if your lordship will see the middle of the page of 48. Now, therefore, in order to ease the difficulty faced by the holders of such mining lease, where stamp duty has been sought paid earlier, the government of Meghalaya, after careful consideration of the matter, hereby order that amount of stamp duty sought paid shall be paid to the government by way of non-judicial stamp within 31st March 2021, subject to condition that 50% of such stamp duty sought is paid and front failing with registration of such lease shall be rendered non-extant. So now the petitioner is seeking to pay this
in installment,
my
lord.
3 installment, my lord. If you also will come back to the miscellaneous application once again, my lord. No, government is going to get the revenue, my lord. And if lords will see the prayer, page 1 of the page para 1 of the application, my lord, of miscellaneous.
If you have no objection, we will allow.
Because it is not in position to pay the whole. That is
the problem is, my lord, legally I can't say that I have no, because and we are bound by the notification, my lord.
We don't know. See, the court's not sitting here. We don't know what's his bank account. What's his financial. So we can't pass. We can't pass only the A also.
No, my lord. The issue is, my lord, that the notification.
It's only if you have to sign. He has to sign some sort of a.
My lord, the issue is, my lord, that the payment, as per rules, the issue is this, that the payment can be made only by way of the installment government has given it, my lord. Now they want to make the payment of this in 3 installments, my lord. So the officer
That is my prayer also, my lord.
These are the facts which I have placed, my lord.
By anyway, within 6 months, they are getting the whole lot, my lord.
Why can you pay the whole lot now?
At present, I am not in a position to pay immediately. Because they have stopped issuing of challan also, my lord.
You are dealing limestone.
Yeah, now no more business.
No, forget about the no business.
Yeah.
You're dealing in limestone.
Yeah, limestone,
Okay, you have a valid mining
border,
lease.
border.
Yes. Take down this. Will this both of the entire matter?
Yes, my lord.
Yeah.
Yeah, but then
Allow us to pay in
you're not pressing your prayers in minute petition any longer.
Allow me to pay in installment, my
No,
lord.
of course, suppose we allow you to pay installments.
Yeah.
The thing is that now you're not pressing your prayer petition any longer.
Yes.
Yes. Take down.
Boulder stone, it's not limestone, my lord, it's a boulder stone.
Border stone.
Okay. The petitioner, who is stated to be the holder of mining lease for operating
Border stone
trade
in West Garo Hills.
Is before this court. Initially with a prayer which is represent below. Just get thought in a prayer. Below stop. However, in the course of proceedings, the writ petitioner has preferred Mrs. application being 223 of November 2026, wherein a prayer has been made to allow the petitioner to make an initial down payment of rupees 60 lakhs. Right?
Yes,
Towards
my
stamp
lord.
duty and registration charges, which have been valued at, which been assessed at rupees 1 crore 95 lakhs 42,341. So, and for the remaining, to be paid in 2 installments within a period of 6 months thereafter. Now, Mr. L.M. Sama, appearing for the petitioner, has submitted that the petitioner, due to the difficulties in
Financial
business
constraint
that has arisen, wherein chalans have been issued, therefore is abandoning the main prayer in petition and prays that consideration be given as prayed in the application. Stop. Next paragraph, the learned advocate general. What is your submission? Submits that what is submission?
Submission that the notification of 2021 permitted the payment of installment up to March 2021 only, my lord.
Mr. General, on behalf of the respondents, has submitted that though the state will stand to gain in terms of revenue, as per the notification dated 18th
February 2021.
The condition therein was that any amount of stamp duty short paid was to be satisfied within 31st March 21, subject to condition that 50% of such stamp duty short paid is paid upfront. So, what's the other submission? It never submits that in your notification, it will not be permissible. It won't be permissible. What is submission? New notification?
It's not permissible. It is not permissible.
Yes,
it is not permissible.
It's not permissible to allow the petitioner's prayer to pay in 3 installments. So, this court has examined the matter in detail, and now, Mr. Elam Sama, how do you propose you give the date?
The date I have to discuss with my client.
You have to give the exact date.
Yeah.
Feeling which then your prayer.
What they say, Milord, in the application, what is being said, Milord, 60 lakh upfront, Milord.
60 lakh upfront they'll pay, but the next payment will be 6 months. When?
And
if it is this week or next week, then after 6 months, after that one, the date I have to check with my client.
Within 6 months.
My lord. Within 6 months.
No, the application is very clear, Milord. If you also will see the prayer.
No, we'll have no. This will be out of the court. It'll be upfront now. 60 lakh.
Upfront.
After 3 months,
Yes.
the 6th installment and the
and again after 3 months.
Yes.
And Attorney General and notes that firstly notes the fact that the petitioner no longer questions the assessment or levy of stamp duty and additional charges, as does not question the assessment and levy of stamp duty as computed, but however has now modified the prayer to allow her
upfront 60 lakh.
pay, yes, as
Then after 3 months, the half of that remaining, and
the
3 months
on a
again.
query from the court, Mr. L.M. Sharma submits that the petitioner is ready to make the upfront payment of 60 lakh immediately.
Yeah.
And the first installment to be made 3 months thereafter, and the final
6 months.
for the period of 6 months.
Yeah, within 6
expires.
months.
So, though the notification, as mentioned, will not cover this situation. However, for the ends of justice, the exercise of discretionary powers under Article 226, the prayer of the petitions allowed. You furnish an undertaking also then?
Yeah, let them.
Yes. But
earlier we have furnished undertaking,
and the
but we
petitioner
didn't allow.
on the payment of the first payment on the first payment 60 lakh shall also furnish an undertaking to satisfy the remaining amounts within 6 months for the respondents within a period of
1 week. Within
2 weeks.
period of 2 weeks from today. Stop. As nothing given for consideration, the petition also closed in this post. Yes.
Milord, on payment of the first installment only, Milord, because the prayer is also to give them the challan, etc. On the payment only of the first installment, challan can be issued, Milord. That's 60 lakh. That order will be.
No, last one.
On payment of upfront money.
On the payment of the upfront amount, the response also. On the payment of first amount and furnishing undertaking, the response also to issue necessary challenge in accordance with laws.
Highly obliged.
25.
Where is the petitioner?
I don't feel this.
Where is not here?
Not here.
We'll dismiss it.
Let it be in the board. First rings.
Let it be in the board. Okay. None appears for the petitioner. Just after 1 week. But he has to go to CAT. That's why he didn't come anymore.
26.
This is a digress matter. They have come before some court, my lord, that the petitioner was removed from service after departmental inquiry. He has filed an appeal, my lord. Now, appeal lies before the executive council
So you
of
withdraw the matter?
My lord, the appeal,
but
is
the
not yet
appeal has not been
considered till now.
disposed of, my lord.
Not considered. Appeal
It's been
considered
5
now.
months.
But the appeal is for sent to
Then?
It's been 5 months. They haven't heard us, man.
sent to the chairman, who is the union health secretary, my lord. It's pending before him.
Now what should we do then?
Also dispose of
Our
it.
limited prayer is to consider our appeal, my lord.
No, no, we'll say that we'll dispose of within 3 weeks. Within 2 months.
2 months, my lord.
1 month, my lord. 1 month.
2 months, my lord. Union home secretary.
Yes, he's been unemployed for 5 months now, my lord.
5 months.
He is removed from service, my lord. After proper inquiry, he is removed from service.
But
Doesn't matter.
right of
Title
appeal, right of appeal is not yet heard,
Let's
my
see your
lord.
prayer. Yes. Yes, take down the petition. The petitioner, who was a fire guard at the respondent of one's institute, right? Negrims? It's number 1, correct?
Yes, ma'am.
That's one institute. On the departmental proceeding was terminated. When was it terminated? On 25 to 26.
25 to 26.
Was
25 to 20.
Was terminated from service by order dated 25/02/2026, whereafter the petitioners had preferred a statutory appeal before the Director and Disciplinary Authority.
Before the Executive Committee Appellate Authority.
Before the Executive Committee. Yes. What's it called?
Yes, my lord.
Executive Committee, my lord.
Appellate Authority. Slash Appellate Authority.
Slash Appellate Authority.
On 24/03/2026. Stop. The grievance is that, however, in spite of the appeal being preferred since 24/3/2026, the same is yet to be disposed of by the Appellate Authority. Stop. Mr. Dakhar, I consider the petitioner submit at this stage that.
4th August, this resolution, my lord, we'll see.
What resolution? You have not filed affidavit.
You have not filed affidavit.
Then?
But the instructions are clear.
No, but.
What is this? If that's reflected, my lord, I'll flag the page. This is the minutes of the 8th meeting of Executive Committee on 4th August.
Okay, that's all. Yes, Padma. And last after Mr. Dakhar submits it. At this stage, there's a praise. At this stage, the repression be disposed of by directing for the appeal to be
heard within 1 month
and settled within a period of
1 month.
Of 1 month. Stop. Next for Dr. M. Muzikanji, I will soon so. Though affidavit not yet been filed, has produced for this court the minutes of the 8th meeting of the Executive Committee for Respond number 1 held on 4th August 2026, whereby at agenda number 43/EC-8 with regard to consideration of appeal of the petitioner against the order of removal from service, it has been reported that the Executive Committee has taken up the appeal and has submitted the same separately for consideration by the competent authority for decision.
Who's the Secretary, Minister of Health?
No, we will not see anything. But the authority is enough. So, in this view of the matter and in the circumstance of the case, like for in view of the submissions of the counsel for the petitioner, that will suffice at this stage for the direction to issue for disposal of the appeals. So, it is therefore directed that the competent authority, who is stated to be the Secretary,
Minister of Health and Family
Health Department or Health,
Minister of Health and Family Welfare,
Ministry of Health and Welfare, take up the matter and dispose of the same within 2 months from the date of receipt of copy of this order. Accordingly, the matter stands disposed of. The minutes of the 8th meeting of the Executive Committee, as produced by the Council, by the learned DSGI, is taken on board with part of the record.
Hello, class.
27.
Please, Your Lordship. Lordship, I was directed to furnish the notice. Here the petitioner actually they were challenging, my lord.
Now what notice here produced?
That the succession certificate case number 96 of 2022 notice was sent to the petitioner, my lord. Because last occasion he submitted that no notice was sent to him, to the petitioner.
Lordship, in this case, what happened actually? No, in this case, what happened actually? We filed a succession certificate. It was granted in our favor. So the succession certificate was granted in our favor, and later on, they filed an application for revocation. During the pendency of the revocation, they filed another application. Just
very good, but then you had noticed that the matter is pending there.
Yes.
Correct. Then
no, that is that.
So why? How you can't look for relief in two forums?
No, Lordship, this is not the case. Well, the two separate subject matters are going in the different court in the parallel proceeding. It's because we first filed an application. After that filing, only we come to know. But that even
contested there. This on put so long, so we won't take it up now.
No, Lordship. One thing is that succession certificate is already granted in our favor.
By the councils.
That has been cancelled.
The councils. Not there has not been cancelled.
It has been cancelled.
Now, Lordship,
back to square one.
Yes, it has been cancelled, my lord.
Now now we are challenging only the procedure, because how can the judge pass an order where he has passed a final order? He has passed a final order, examine our thing, then they have granted the succession certificate in our favor. Now we are not disputing. They have done the correct procedure. They filed a revocation application to revoke that order. That we are admitting.
The succession certificate should feel the petitioner is recalled.
Yes.
And shall remain discarded.
Yes.
That's why we are saying.
So why not contesting it there?
That is another issue. That only
that's the main issue.
The only thing is that
if you're holding a valid succession certificate in your name, and another, another matter is proceeding there, then yes.
In fact, the succession certificate was initially filed by us, my lord. Here in their own admission in the annexure, my lord.
What they've done is that they've come here and filed.
Yes.
No, that is because we have no knowledge whether that another succession certificate application was pending there or not. That we don't have.
No, but where's the factory of service? Notice issued to her, but where's shown that she received? It's not here.
We have not. That's why repeatedly we have said that we have not received prior to filing of
the Nazir, my lord.
When Nazir just you threw up for fear of causing service and returned the same in time. Where's the acknowledgement by the Nazir or by the that's been served? It's not there.
No, but they're very much aware, my lord, that the matter was pending there.
We came to aware only when they filed an application for revocation.
We'll produce those documents, my lord. Because this is the second date today.
They are not
because Lordship last occasion.
Today, Mr. A.G. Mohan has produced a notice issued on 12/01/2023 for service of notice to the writ petitioner in a succession case number 96 or 2022 for the Court of Direction District and Civil Judge Jithir Tura stop. Because Mr. P.D. Sama denies that the same was ever received by the writ petitioner of on this denial, Mr. Ejun prays that you will allow
Lordship.
to produce for the document.
For the documents.
Yes. Otherwise, no point. You go there. It's come to zero. You can't maintain it. Now you want to hear the matter now.
Our case is that because they have already issued in our paper. Now they have filed a revocation.
See, they have issued in your favor. It's been revoked, been discarded. Now they say since the succession matter is pending.
No,
Garments, you go there.
That revocation was not. That revocation petition is still pending. Still pending. How can they pass in the Lordship? Lordship. Hello, Lordship. Much less, Lordship.
What do this matter?
Lordship, here as per the last order, Lordship, there was a suggestion put up by the state respondent. So now,
Your Lordship, the managing committee was supposed to come with instructions.
Have you approached them? Then?
Let her to file an affidavit, and after that, my lord can give a direction.
I'll take instructions also, Your Lordship,
Yes,
on the
Lordship.
representation.
10/7/2026.
Yes, Lordship.
This court had allowed the managing committees to find appropriate application before the state respondents for consideration. Today, MSZ Begum for respondents 9 to 23. Somebody is yet to receive instructions. Only a matter of 2 weeks to allow her to obtain instructions. It was further directed that MSZ Inonkondi for 124 also to obtain instructions.
Your Lordship, if the representation has been filed, Your Lordship,
she can file by way of an affidavit, Lordship.
No, we won't pass the orders. Let's see. If instructions here you haven't filed your representation, then too bad.
She has filed the representation.
She
has filed the representation. Now she wants to file by way of an affidavit.
Though the representations have since been filed by the concerned respondents, concerned managing committees.
It can be disposed of only by directing. They can take a call on this at representation.
Yes.
the next matter is a connected matter, Your
28,
Lordship.
Yes.
Obliged, Your Lordship.
This after 3 weeks. Okay.
30.
Customer hearing.
Lordship, that is that matter, Lordship, where petitioner are serving as head constable in BSF, Lordship. And in spite of serving for close to 35 years, they have not been promoted, Lordship. Petitioner's case is that similarly placed head constables have been promoted, Lordship. Because there is a mandatory requirement of 3 years diploma in electrical education, diploma in electrical engineering, Lordship. Sorry. So the similarly placed head constable in other streams have been promoted, Lordship, and the department have submitted a rule wherein they are saying that those who have been submitted do not require this qualification, Lordship. Lordship, I will take my Lordship to the rules submitted by the department on the last occasion, Lordship. There are 2 rules which have been submitted, Lordship. One is notification dated 10th January 2012, and the other one is 3rd March 2015, Lordship.
Now you have diploma?
No, Lordship. I have acquired, Lordship. We have acquired, Lordship, but because it is through distance education and through AICT notification, distance education, Lordship, through correspondence.
Oh, distance education, okay.
Now, what has happened, Lordship?
Where have the response said that you have to have the weather requirement for diploma in electrical engineering? Where has spoken say promotion?
Lordship,
where can we get that?
The notification, Lordship, dated 10th January 2012, Lordship. There are 2 notifications, Lordship.
That's not a record in the petition.
Lordship, the department. Lordship, on the last occasion, learned DSEI had submitted, Lordship. Place it down.
It's not an affidavit.
Not in affidavit, Lordship.
Why?
Page 36, revised total rules.
Of the affidavit?
Of the
writ petition also is this.
Of the writ petition.
Is there? Yes. Page 36.
36, Lordship.
Okay. Where is that, Dr. Mojika? Where's that? Page 36.
Lordship, it is there in the counter affidavit filed with the respondent, Lordship. Page number 39, Lordship.
Now you want to be head constable, right?
We are head constables,
Now
Lordship.
you want to be
Sub-inspector, Lordship.
sub-inspector.
Lordship.
But you've been granted, is it a post that has promotional avenues?
It is, Lordship. 60%
Not
post.
an isolated post.
No, Lordship. 60% seats are reserved for promotional cadre, Lordship. 60-40 ratio.
Then where we said that where the other cases where without having
I have placed on the court, Lordship.
with this
Lordship,
qualification they've been promoted
Lordship,
sub-inspector. Where is
I
that?
placed additionally for the affidavit, Lordship, and page number 5, annexure A.
Page
I placed
number?
5, annexure A, Lordship, my additional affidavit, Lordship.
Yeah.
May I read, Lordship? Para 2, Lordship. As approved by the competent authority, number so and so, head constable, bracket VM, that is vehicle mechanic, so and so, SRO BSF New Delhi, who was brought on consolidated select panel MTW2, White's Frontier headquarter, province so and so, order reference is hereby cleared for promotion to the rank of SI, Lordship. VI. And there is next, page number 7 also, there is another one, Lordship, similarly placed head constable.
Vehicle mechanic and electrical engineers is on the same.
Lordship, the educational qualification is the requirement is the same, Lordship. 3 years diploma, Lordship. Next page is head constable, auto electrician, Lordship. So and so has also been cleared for promotion, Lordship. Next page number 7, Lordship.
He also in mechanical.
They are technical group, Lordship. They are, all these are in technical cadre, Lordship. Electricians, vehicle mechanics, auto electricians, they are in technical cadre, Lordship. So petitioner's case is that similarly placed head constables, because of their long experience in service, Lordship, they have been cleared for promotion to the higher grade, Lordship. So petitioners ought to be considered for, Lordship. Lordship, the education requirement of education qualification, Lordship, for vehicle mechanic, Lordship, in the last notification placed by the respondent, Lordship, it's there. Minimum 3 years diploma in automobile engineering or mechanical engineering or auto electrical engineering from an institute recognized government, Lordship. So that requirement is for them also, Lordship. In spite of that, they have been cleared for promotion, Lordship. They can consider sub-inspector technical vehicle mechanic. This is number 13.
Okay, before there was no scope promotion. Now there is.
There is, Lordship.
After the revised recruitment rules.
Lordship, I've given my notes already. Lordship, I have notes.
What notes?
I've given them.
You and your own looks torn. When did you give it?
I supplied them, Lordship.
No, but if you've given the others,
But others are not from distance education, my lord. But here the main issue is, my lord, he has obtained his engineering from a university. Number one, from distance education mode, my lord, and number two, that university distance education is not recognized by AICT, my lord. There are specific instructions on that, and plus that university has been wound up by Sikkim government, my lord. If I lordship just have text of my note, my lord.
or is this the note? This is the one.
Yes, my lord.
You can copy to him.
Lordship, I have, Lordship. Lordship, my case is that I'm not even considering the education qualification, Lordship. Similarly placed head constable,
His
Lordship.
assumption is that even without considering the education qualification, he is eligible.
Lordship.
Cannot be, my lord.
Can it be?
Cannot be.
Because this similarly placed head constable in vehicle mechanic and auto electrician, Lordship, they have been promoted without the requisite additional qualification, Lordship. That is my case, Lordship.
So your stance that he has to have 3 years diploma, electrical engineering from a recognized institute,
and through regular,
and also couple of 10 years regular service before that, to be eligible for promotion.
Yes, madam.
Right. So you say his diploma is not on only that ground, not recognized, so he can't be considered for promotion.
Yes,
Where is that you showing that you don't have? Just now again, the same one.
Lordship,
that additional affidavit.
Additional certificate, Lordship.
Let's see again, what is this? Does it say anything there?
It doesn't say anything, Lordship, but it's
how do you say that they don't have the additional qualifications?
Lordship, only
this only as approve a government authority, so and so and so and so. What consists like panel, so and so, you have a promotion rank of SI. And then
Lordship, only the department.
How do you know that they don't have this qualification?
Only department can, Lordship, produce their service records, Lordship. Because
you can't make them do your case for you.
Lordship, because they are colleagues, Lordship, and
then
they know for a fact, Lordship, that
you must be knowing them.
They know, Lordship. They know that, and they, as per the verbal instruction received from this person concerned, Lordship, they don't have education, additional qualification, Lordship. Based on experience only alone, Lordship. Because from head constable to sub inspector, Lordship, they will be working in the same establishment, Lordship, same floor. So they'll be repairing the same vehicle, Lordship.
BSF won't accede to that. Even for a person seeking to take leave for
Lordship.
In the same line of work, so they're denying that.
Promotion.
In the other case, you're not allowing him leave. Then, even if you want to go for diplomas, they don't allow you.
They are not allowing. One of the players, I have one of the players, Lordship.
Yes. So you don't allow to go to diplomas, you won't get promotion. If you get distance also, it's not recognized. So what are you going to do?
Lordship, they may consider my promotion on similar lines, Lordship, at parity.
They can't consider if nothing is there to show. How will they consider? They say that other people have. Are you sure? That is affidavit. Have you taken instructions on that? Filed by.
Well, last occasion, what happened, my lord? We were required to place the rules, my lord. So we just placed the rules, my lord.
No, forget the rules for now.
These rules, now, Lordship, will support petitioner's case.
Two people, who have been head constables from vehicle maintenance,
Lordship, and auto electrician, Lordship.
Yes, an auto electrician. Whether the promotion was without the added qualification. That's the only thing.
Lordship.
When are you going to retire?
Lordship, we have already served. We don't have much service, Lordship. 6 to 7 years.
30 years.
35, Lordship. And their legitimate expectation, Lordship, at the time of retirement, Lordship, they would want to.
You have been promoted once.
Not even once, Lordship.
ECP, right? You've
ACP,
been given
yes,
your
yes,
ACP
yes,
twice, my lord.
MSCP, Lordship.
Twice they will. Third one they'll get in due course, my lord.
Lordship, but MSCP and promotion are two different aspects, Lordship. Okay. To retire as head constable and to retire as sub inspector, Lordship, it makes a lot of prestige issue, Lordship. And it is their legitimate expectation, Lordship.
No, anyway. Yes, stop. In the course of hearing, Dr. N. Muzikali, GGI with so has maintained that the petitioner was not considered for promotion to sub-inspector in view of him not possessing a diploma in electrical engineering from a recognized institute. Mr. S. Pandey, however, has reiterated that as given in the additional affidavit filed on
That's it. 27/2/2026.
The petitioners annex therein 2 orders of similarly placed head constables, which he submits, though not having the requisite qualifications, have been considered and given promotion. However, from the orders, the same is not evidence as to whether the persons named in these orders possess any additional qualification as prescribed. The learned BSI therefore is requested to obtain specific instructions with regard to the 2 orders dated 7 May 2024 and 16 August 2024 next to the additional affidavit of the petitioner. Just after
2 weeks. 2 weeks.
2 weeks. You get instructions.
Yes.
31.
Grateful, Lordship.
And if it's that, then you'll go for consideration. If it's not, then you.
Yes, Lordship.
31.
Item 31, Lordship. Connected matters, Lordship.
33.
To be obliged, Lordship. 33.
Please, Lordship. Lordship, this is a pension matter, my lord, where I was working as a driver, as a regular employee, and then was retired on 28 February 2023. Now I filed this petition only for direction to release the pensionary benefit and other service benefit. Now the state respondent in their affidavit, paragraph 6 and 7, they have admitted that they are on the process and they are trying their best to release the pension. That is a stand. Therefore, in another repetition, my lord, where in the WPC 75 of 2025, similar situated case, in order that is 02/07/2025, Lordship has passed an order where the state respondent have no objection to release the pension. Then I'm as a employee, I'm entitled for the benefit, and then they have the order in the para 4 of the order, judgment in order. The Lordship has passed this order.
You have a copy reading only.
Lordship, yes, Lordship. I mean, just kindly see this one. Now there is a private respondent herein. He is saying that only say that that I am my pension should not be released. This is the order.
Why she should not be released?
Because she is saying that she is my wife. But however, now this is not the case by where the 2 wives are fighting, because she is my wife, but her right will come only after my die. This is
have another wife also.
Now actually that is their allegation. I don't have any other. No.
You have only one wife.
Only one wife is there.
Who's that?
But
it's not her.
She is the private respondent here.
She is the wife.
She is the wife. So she has.
Why you objected?
Your Lordship, here I am for the first wife, Your Lordship. In fact, Your Lordship, he has a second wife, Your Lordship, and he's staying together with her, Your Lordship.
That is their allegation only. So they have not bring any certificate or sort of. So they can just take a.
Your Lordship, the main reason why we approached the Office of Respondent, Your Lordship, objecting to the disbursement of the pensionary benefits in favor of the petitioner, Your Lordship, is that, Your Lordship, we have a strong apprehension, Your Lordship, that he will substitute my name, Your Lordship, with his second wife's name, Your Lordship. And that is illegal, Your Lordship, because of the fact that decree of divorce has not been granted, Your Lordship.
You came and pleaded yourself.
Yes,
How many
Your
children do you have? They all major?
5 children, Your Lordship. All are major, Your Lordship, now. So, Your Lordship, in this.
You retired 23.
28, my lord. On 28, yes, 23. 28 February 2023.
You file affidavit also?
Yes, Your Lordship. Your Lordship, here my Only pray is that your lordship may kindly grant me assurance, your lordship, that the petitioner will not change the name, your lordship. Only with regards to the name, your lordship, that he might not change.
He's entitled to his benefit. He's still
Yes,
alive.
yes, your lordship.
So before
Have you
he's not
considered?
dead.
After my death, if they allege that if I have another wife, they are free to come to the court and fight it with, because now, as of now, I am denying also that I have another wife. That is their allegation.
So 5 children you have from the first wife, you don't know them.
No, I'm not denying, my lord.
Then now you see,
No. They are alleging that I have another wife. That's why they.
She's the only wife. Then we record that she is the only wife, the respondent.
That I need
allowed to be recorded. We will record it.
No.
Then now the truth comes out.
But officially, actually, she was wife, but she has run away actually.
No, your lordship, he was the one who
ran away.
She ran away actually. I've stated in my rejoinder also.
You ran away from each other, or one ran away from you?
But
that's all in jest. But then you see,
with regard to pension and benefits, because there was little mistake in the initial pay statement for the year 2009.
It's been corrected now.
That was corrected, and he has already withdrawn the GPF also. And now the it is
whatever
for the finance department. But with regard to family pension, we have requested him to produce the the marriage certificate, family photograph, and the children birth certificate for verification. But he has not produced. So
how he produce? How he take a family photograph with her now?
that's the problem is about it. So
it's a problem of your own making. You know that you have to give a joint photograph. You know that, right?
Yes.
Before when you your pension papers.
Yes.
So whose photo you'll give?
I'm not given.
You won't be able to give. It's of your own making. Then you won't get your pension also until you satisfy that requirement. This is the picture you've seen the form, right?
Yes.
There's a joint picture of 2 of you, then so and so, then like your marriage certificate, your wife, and these are the children. You've drawn the GPF also.
This is drawn for India 2023 December year.
How will you resolve? It's up to you to resolve. Court can't do anything. First time Mr. Petitioner lost for words. Otherwise, yes.
I'll get the instruction, my lord.
What instructions you'll get?
Because from the whether regarding the documents.
You accept her that she's the first wife. You'll take picture with him, right?
Naturally.
Yes. Yes, Mr. P. Sama prays for how to to obtain instructions. Otherwise, it's your own making. You won't get a pension.
Yes.
36.
Most
Yes.
Just before the state responds, with your lordship's permission, may just state a point of procedure, my lords. I was just going through the High Court rules. There are 2 problems that may be presented. Your lordships heard this matter in substance the other day, and whatever tentative view that this matter should be placed before a division bench.
Yes.
The High Court rules under Chapter 3.
Petitioner has been heard.
Correct.
Has not been heard, my lord.
I never said both parties are heard. What I'm saying is the High Court rule provides that in matters which can be taken cognizance by the division bench, under 4D it says that taking into consideration the importance or complexity of a case, the petition as a whole has to be referred.
Yeah.
Now, what the state is proposing is that the substantive part need not be going to. I think at some point, if I'm allowed to finish.
I have not argued.
Please let him finish submissions at least.
It's before your lordships to consider. So the petition as a whole has to be sent to the Chief Justice as a reference to be placed before a division bench. Now, the petition will meet the entire thing. We can't bifurcate. So the High Court rules does not prescribe a procedure for bifurcation of the issue. Now let's say, what is the practical difficulty? Now let's say your lordships decide the issue of maintainability in my favor, and the state is still aggrieved, and the matter is then referred to a division bench. Where does the state prefer its appeal against that issue of maintainability? So, in my humble submission under Chapter 3, the petition by itself has to go, the entire gamut.
Mr. We'll send it to division bench. better.
Lord,
They can raise this point there, Milord.
Your Lordship, kindly hear me, then thereafter, Your Lordship, whatever Your Lordship decides, I bow down, Milord.
No, it's better also. It's a very important question. Whether you see, whether you know see the only consideration is this: whether they are two separate categories altogether, and whether you can club them together. That's all.
May I now, Milord, this issue is settled. This issue, may I submit? And if this issue is not settled, Your Lordship may refer it to division bench. I have no objection, Milord.
The latest Supreme Court decision says that that is different. Yes.
Yes, Milord, even Your Lordship's order also, kindly hear me, then Your Lordship may take a call, whatever is Your Lordship's call. I bow down. Milord, see, what is the case of the petitioner before Your Lordship? First, Your Lordship has to examine what is his case in the petition, Milord. Just see the petition, writ petition, Milord.
Yes.
2-3 paragraphs, because Your Lordship will refer which has some submission, etc. Your Lordship will kindly have page 18 of the writ petition, Milord, paragraph 20. I am placing the case of the petitioner as stated in the writ petition. Paragraph 20. There is no dispute that tribes and castes are distinct and completely heterogeneous. They cannot be treated as identical. So the case of the petitioner in this paragraph, Milord, is that they are heterogeneous and therefore they cannot be in homogeneous group, Milord. The state has to respect the salutary objective of reservation, which is to provide equal and equitable representation in matters of public employment and ensure that vacancies are distributed in a fair manner by ensuring representation of scheduled caste. So in essence, what is being prayed before Your Lordship is this, that there has to be separate reservation for scheduled caste in the reservation policy, and Your Lordship should issue mandamus to the state that there should be separate reservation for scheduled caste in the reservation policy. This is the direction which is being sought.
Yes.
Now, therefore, my Lord, this is, and on what is the basis for seeking this direction? On the ground that they are distinct and completely heterogeneous, my Lord. That is the ground on which the prayer is made in this petition, my Lord. Now, I don't see any other provision of law which has been cited, only that it is a violation of petitioner constitutional paragraph 31, my Lord, which says that it is a violation of petitioner constitutional right. Now, Your Lordship will have to determine what is the constitutional right of the petitioner to seek direction to the state that there has to be separate reservation for scheduled caste in the reservation policy, and therefore if the policy provides for reservation of separately for certain scheduled tribes and certain scheduled castes in one category, it is violative of constitutional provision. I don't see any other constitutional provision which has been cited, only except Article 16, if Your Lordship will have paragraph 24, where the petitioner says, that is also irrelevant, my Lord. It is humbly submitted, state government is conferred with power to provide reservation and to distribute it equitably. It is obligation of the respondent state to attend to the apparent wrong and ensure adopt a distributive justice method in sphere of public employment in order to promote underlying object of Article 16 of the Constitution. So the idea or is that if there is a homogeneous reservation, it is violative of Article 14. And therefore, this policy should be struck down. Direction should be issued to the state government that there should be a separate reservation for scheduled caste, scheduled tribe. Now, Lordship kindly have the preservation policy, my Lord, which is there in Annexure R2 at page 41 of my counter affidavit, my Lord.
File by
this is
1 to 5.
Yes, my Lord. This is a counter affidavit, page 41, my Lord.
Yes. 41.
And if Your Lordship will have this policy, yes, page 41, C, my Lord. C.
1 second. Which affidavit is this?
It's one.
This is a counter affidavit.
1 to 5 short affidavit.
Yes, madam.
Short affidavit. Short affidavit. Page 41 is something else. 1 second. Oh yes, okay. Page 41. 39, 40. Yes, 41, right.
Yes,
Well, because there are 3 page numbers. It's scored out and then again.
Yes, my lord, that is the problem which I face all the time, my lord.
At least when you write the page numbers, please make them distinct. Yes.
There shall be reservation of 5%. If your lordship will see, there shall be a reservation of 5% of the vacancies in favor of any other scheduled tribes and scheduled castes as specified in the 4th schedule and 2nd schedule respectively of the said act insofar as they relate to Meghalaya.
Yes.
So 5%, my lord, of the vacancies in favor of scheduled tribes, and this has been further modified, my lord, at page 42, my lord.
Yes.
Now, see, my lord, there shall be reservation of 5%. Next page, your lordship has the next page, my lord. This was modified on 25th November 1976, my lord.
Yes.
Now, see, there shall be reservation of 5% of the vacancies in favor of the name of the scheduled tribes are Rabhas, Bodo, Kacharis, and Koch permanently residing in Meghalaya, and any other scheduled tribe and scheduled caste as specified in 4th schedule so far as they relate to Meghalaya. So this is a class which has been created.
So this class is subclass 1 and 2.
Yes, this class consists of, my lord, Rabhas, Bodos, Kacharis, and any other scheduled tribes which are reside. Apart from, your lordship has seen, Khasis and Garos, they have got separate reservation.
Yes.
Now the petitioner is posing a question to this honorable court, is that the government has no right to come out with the policy for scheduled caste. There has to be separate reservation policy.
Yes.
Now the question which is squarely falls for your lordship's consideration is, before I take your lordship to the backdrop of the certain facts, my lord, that this petitioner, my lord, I will take to the legal question also, but the first question which is there, because I just prefaced my argument with the legal issue, this petitioner, my lord, participated in the selection process.
Yes.
By advertisement dated 11/2/2022.
Yes.
And this 30 post of Meghalaya Civil Services junior grade was notified, my lord. Revised advertisement was issued on July 23, and in the advertisement it was clearly said unreserved will be 5, Khasi and Jantia 14, Garo and 14, and other ST/SC 2, my lord. He participated in this category, and my lord, he failed in the result. Final result was declared on 17 January 2025. All 35 notified vacancies were filled. Two posts are marked for other SC/ST category were also filled. Petitioner who failed below cutoff mark, he was not selected. My lord, once you have participated in the process, you cannot challenge the process. That is one aspect of the matter, my lord. I'm not, because now second, the rules of the game cannot be changed, my lord. Those judgments are, your lordships are aware, there are number of, after having failed, now he is saying that, look, reservation policy is bad, and it should be struck down because there should be separate reservation for scheduled caste in the state of Meghalaya. And this is also not tenable, my lord. I will place the short note, my lord, if your lordship will permit, with the relevant citations, my lord.
Short note, what short note?
Yes, note of submissions, my lord.
This is good. Pass others.
Please give it to the other side also.
And this, but you visit judgments.
Lordship, straight away, my lord. Straight away, lordship may come to page 3, my lord. And paragraph 8, my lord. My lord, that will save time. Para 8 at page 3, my lord. Pages are important. 7 and 8, my lord. Permit me to read these paragraphs, my lord. The state reservation policy was notified by resolution number so and so dated 12th January 1972. It marked 40% vacancies for Khasi, Jantia candidate, 40% for Garo, and 5% for candidate belong to other scheduled tribe and scheduled caste, then forming part of Assam upon reorganization of the state falling with the state of Meghalaya. Following the reorganization of the northeastern states under the Northeastern Areas Act 19, position was expressly clarified by OM of 1972 having regard to section 25 and 26 of the said act and following effect, my lord. I have read this these two notifications, my lord. Now kindly have paragraph 10, my lord. Two matters follow from the instrument themselves. First, 5% quota is a single undivided quota available to a defined group of micro-minority communities of which scheduled castes form part. Secondly, policy does not exclude scheduled castes from reservation. It places them within the shared quota along with comparable place community. The relevant provision consistently creates one composite 5% reservation in favor of scheduled tribes, communities and scheduled castes commensurate to their small population in the state. The character, so lots of make smaller population, the character of this reservation is therefore clear. 5% quota is a common and undivided pool within which identified communities are entitled to compete on the basis of merit. The expression scheduled tribes and scheduled castes in the policy is not implied to create two distinct compartments within 5%, nor is there any stipulation that 5% must be further bifurcated among the constituent communities. The policy, as framed and subsequently modified, consciously adopts a single composite category for these communities. This distinction is material to the controversy at hand, particularly in constitutional and historical setting of Meghalaya, with predominantly tribal population and the state enjoying a special protection in this of the 6th schedule. The reservation policy must be understood in the distinctive context. It was framed to preserve the delicate balance among the indigenous tribal communities of Meghalaya and to ensure that limited opportunities available in the state are distributed in manner sensitive to unique demographic, social and constitutional character. Now 11. The composite 5% reservation reflects that considered policy choice. Petitioner before this honorable court seeks that same be transformed into a separate quantified reservation for the relatively small population of scheduled caste community to afford greater representation to them when the state has deliberately placed these white small tribal communities and scheduled caste within one common category commensurate to the population and other relevant factors. In the 6th scheduled state, where protection and advancement of indigenous tribal communities constitute a constitutional imperative, the petitioner is seeking to recast carefully calibrated reservation policy or substitute a different allocation merely because another arrangement may appear preferable. Where the state has consistently prescribed a single 5% reservation for defined class of communities having regard to the unique demographic realities, it most respectfully submitted that policy ought to be accepted as an expression of Meghalaya's unique constitutional identity and its obligation to preserve the interests of population predominantly belonging to scheduled tribe. Now, my lord, this 5%, my lord, idea is just 5% community, my lord. I will not trouble your lordship with paragraph 12 and 13, my lord. 14, your lordship may have it paragraph 7, my lord. That
why now? Yes. Now, why? How is it constitutionally valid? As a 20, you saying?
See, that is what I'm straight because constitutionally, because your lordship will have to say that the state has no right to club the minor communities into a separate class. That policy choice is not there because it is offending Article 14, etc. Lordship, then your lordship will have to say and return the finding. This issue, my lord, is no longer res integra, my lord. If your lordship will see, this issue came for consideration before the Honorable Supreme Court and before this court. Kindly have paragraph 15, my lord, where I have quoted the relevant part of the judgment. Paragraph 15 at page 7. Paragraph 15 of the note, my lord. 1.5. Your lordship has paragraph 15 of the note. Yes, your lordship will. This the very constitutional, your lordship, paragraph, the constitutional validity of such grouping finds direct support in the the constitutional validity of such grouping finds direct support in the Constitution Bench judgment of 7 judges in a state of Punjab versus Devendra Singh. Constitution Bench, while considering the permissible contours of classification within reserved classes, recognized at paragraph 150 the wide power of state to employ the range of means to secure substantive equality. Article 15.4 and 15.5, it was observed therein. Article 15.4 recognizes the power of state to make any special provision for advancement of any socially and educationally backward class of citizen or for scheduled caste or scheduled tribes. Article 15.5 is similarly worded. It was submitted before this court that the use of proposition any before socially and educationally backward class as opposed to the phrase the before the scheduled caste and scheduled tribe indicate that scheduled caste and scheduled tribe are homogeneous integrated class. We do not agree with this submission.
Yeah.
So what is being submitted is that they are homogeneous integrated class, and therefore what is being pleaded before your lordship is that scheduled caste and scheduled tribe, the other scheduled tribes, are not homogeneous integrated class. The provision provides that the state is power to make any special provision for scheduled caste and scheduled tribe. Thereby, it recognizes the wide power of the state to employ a range of means to secure substantive equality. This would include sub-classification within scheduled class. So my submission, my lord, is that if the state has created 5% reservation policy for named scheduled tribe and other scheduled tribe and scheduled caste as one homogeneous group, this is the policy per se cannot be held to be bad in law or violative of Article 14. And this choice is reserved for the state government. Now, my lord, 16, if your lords will see this, the next part, Constitution bench at paragraph 208 expressly recognize the fact that constituent caste may be separately anti-favorable, does not by itself require the state to create separate reservation for each subcaste. In the case of scheduled caste, my lord. Now, if they say that if there is a recognized, though in each caste is a separate unit, social backward suffered by each is not substantially distinguishable to warrant the state to reserve the seat for each caste. Now, if the social backwardness of two or more classes is comparable, they may be grouped together for the purpose of reservation. Now, kindly apply this principle in the case of Meghalaya, my lord, where we have the reservation to the extent of 80% and 5%. And
you are banking on this 208 paragraph. That's not
208 and I'm banking on paragraph 155, which says that the state has wider latitude when it comes to the policy decision. Now, kindly juxtapose these principles in the facts of the case of Meghalaya, my lord. The Meghalaya is a 6th scheduled state. The substantial representation is given to two communities, and the scheduled caste and other scheduled tribe, though they may be here in Meghalaya, but they may or may not be indigenous, and scheduled caste may or may not be indigenous. That is why state in its wisdom has clubbed them together into 5% category, my lord. So this choice, my lord, to say that it is offending Article 15.5, or because, my lord, they have to show that there is something which is there, my lord. Now, this logic, my lord, if your lords will see, has been explained in paragraph 17. Principle is directly applicable to present case. The state has adopted a common 5% quote for communities which, having regard to their size, representation and circumstances within Meghalaya, were considered to require reservation. The state was not constitutionally required to fragment this limited 5% quota into separate compartments for each constituent community. Indeed, such fragmentation would defeat very objective reservation, creating compartments so small that meaningful reservation for the constituent community would be practically unworkable, my lord. Now, if lordship has seen that if the state has to say that we have to have for Rabha, Boro, Kacharis and Koch permanently residing in Meghalaya, 2%, 1.5%, then scheduled tribe, other scheduled tribe 1%, and then scheduled caste 1%, the entire policy will get defeated, my lord. Entire policy will become unworkable, my lord. Now, 18, my lord, the petitioner's proposed approach would effectively require the court to impose upon a state to model of compartmentalized reservation within constitution itself does not mandate. Question is not whether constituent community can be separately identified, whether their circumstances are so materially different. For the purpose of reservation policy, the state is constitutionally prohibited for treating them as a common class. In Devendra Singh answers the proposition in negative, where classes are comparably situated for the relevant purpose, my lord. So, your lordship has the parameters like the three parameters which we have said, my lord, that the circumstances are such, my lord, for example, size, representation and circumstances. All three factors 1972 policy accordingly represents a constitutionally permissible method of securing substantive equality rather than excluding any constituent community from benefit of reservation. Policy places the identified communities within the common pool and permits them to compete for vacancies reserved for the pool on inter se merit. No community within the pool is on the face of policy denied access to the reservation, or nor is constituent committee given an exclusive so and so. 5 course. And then, my lord, this issue, my lord, Devendra Singh also in paragraph 20, my lord, the distinction is decisive in the context of Article 341 to paragraph 220.4, my lord, explain the constitutional provisions, and then it says that in that case it was held that we are not saying that one community will have higher reservation, it is exclusive. All 5% is thrown open to all the communities named in the policy, my lord. So to say that the policy is bad, there should be separate policies against the law, my lord. And my lord, kindly have 2 judgments, my lord, in paragraph 23, which I have referred to, my lord. Paragraph 23 at page 11. The 23 at page 11.
Yeah.
Notified category structure is a policy choice, my lord, is the heading D, my lord. The relief sought by petitioner by way of instant proceeding is that 1972 policy be set aside to extend club other SC/ST in substance is a prayer of this honorable court direct state restructure reservation policy in a particular manner. In this case, it is opposite referred to decision of State of Punjab versus Anushka Goel, where the honorable Supreme Court set aside a direction of the High Court requiring the state to enlarge quota to 1% to holding paragraph 10. A consensus policy decision was taken by state government to provide 1% reservation quota for sports person. High Court has exceeded jurisdiction while issuing the writ of mandate directing a state to provide a particular percentage of reservation for sports person while exercising power under 226 of the Constitution of India. What my friend's client is asking or demanding from this honorable court by way of that there should be separate 1, 2, 3% reservation for scheduled caste out of 5%, and my friend's clients are asking that they should not be part of 5%. That is the case, my lord. Now, there are 2-3 judgments, my lord. I will place those judgments on this aspects, my lord, separately. And last page, my lord, if your lordship will have this issue is no longer why I oppose, my lord, the matter to be referred to the division bench, my lord. If your lordship will have page 13 last line, my lord.
Yes.
In Greneth, M. Sangwa versus State of Meghalaya,
page
decided on page 13 last line, my lord. Page 13 of the in Greneth.
It doesn't match.
Last,
page 14. In Gannett M. Sangwa.
Yes, my lord. The Honorable Division Bench declined to adjudicate upon reservation roster, observing that these policy matters left to the legislature and executive, and it would be open to be affected person to question propriety forms. If the roster is policy now, these are the policy matters that are best left to legislature and executive, and upon firm stand being taken, it will be open to its affected there to question the propriety themselves in accordance with law. As of now, without decision in such regard having been taken by assembly which is acting and discussing matter, present petition should not be entertained PIL without going into merits of matter pertaining to roster system reserve system. So it was in the context of roster system and this, my lord. So my submission is, my lord, that ultimately on the issue which is being argued before your lordship is covered by the judgment of the Honorable Supreme Court. If there is an ambiguity in the policy or the law, your lordship, or requires some substantial consideration, my lord, your lordship may refer this issue, because if it is referred to the division bench, my lord, the effect would be I will be deprived of right to appeal, or the other party will also be deprived of right to appeal to the division bench, my lord, when the issue is squarely covered, my lord. And now, my lord, coming back to the other issues, my lord, kindly have this petition is also barred by the principle of estoppel, waiver and acquiescence, my lord. Now, if I can take your lordship to the relevant judgment on this issue, there I have given the number of your lordship may have the index of judgments relied upon me on this issue, my lord. Index of judgments relied upon by the state respondent, my lord. It's a one page, 2 page.
Now in this Devender Singh, I'm not going to.
Yes, please.
How these? It was a one.
It was a case, my lord.
No, 1, 2, 3, 4, 5, 6, 7 judges, correct?
Sir,
now, how many judges tendered their own? Their opinions.
In fact, if your lordship will see the judgment, I have given the. If your lordship will just take up the judgment, and
Justice Gawai gave his own opinion, then Justice Chandrachud, then Justice Trivedi.
The only the concurring opinion is I believe Justice.
Which page is that?
Gawai is concurring. Justice Gawai gave a concurring judgment with the majority bench.
Justice Trivedi.
One dissenting opinion is there, my lord. I checked.
B.M. Trivedi.
But yes, my lord. Justice Bela Trivedi's view, my lord.
Any action to state the name of affirmative action is not permitted by the Constitution, could not be validated or vindicated by the courts by molding or tinkering with the specific provisions of the Constitution. Is that her view?
That was also the view taken by the bench in 2005.
Yes.
In
155.
That any kind of subclassification would amount to tinkering.
Let's say you revisit.
Yes. That's the judgment of 2005 in EV Chennai.
Take consideration Indira Sawhney.
That struck a discordant note with Indira Sawhney.
If I can, what has happened in this case, my lord, that the issue arose in this case that there was a separate reservation for Balmikis, etc. in Punjab, my lord. A special reservation, and they were given exclusive reservation. That was challenged, my lord. If your lordship will see the paragraph.
I've not really read this judgment in detail.
It's page 89, para 7 of the facts.
Your lordship kindly
has. Yes, I'm not looking at the facts. I'm looking at the
155, my lord. 155.
Justice Virkamnath also gave a concurring judgment.
Yes, all these are concurring. So
Justice Trivedi's is
only one. Yes, my lord. It's there at page.
Dissenting judgment.
Page 86, Lordship will find the name of the judges who's given a concurring judgment, majority view and the minority view. Page 86, the first paragraph.
Yes. So
in view of this judgment, my lord, there is nothing left to be decided, my lord. If your lordship will see the paragraph, the beginning only, page 86, your lordship has noticed that Justice Chandrachud for himself and Manoj Mishra, B.R. Gawai, Vikram Nath, Pankaj Mittal and S.C. Sharma justices concurring. Bela Trivedi justice
dissenting.
Is dissenting, my lord. So and then your lordship will straight away see 155, 2-3 paragraphs only, my lord.
No, that's okay. Yes, please proceed.
And one more paragraph, if your lordship will have that one more paragraph, 220 also.
That's all right. Please proceed. Yes.
208, my lord.
No, come back to your note.
Yes, my lord. So, my lord. So then
now you have come to even acquiescence. Now, which judgment are you placing?
Yes, my lord. For the given, yes, is Anupal Singh, my lord. Before that, my lord, kindly have the certain facts before your lordship. This candidate has, because I have given the relevant paragraphs and judgments also, my lord. I can place all those judgments one by one. That first proposition which I have, my lord, is the prisoner having participated is stopped from challenging, my lord. These are the 6 judgments, my lord. Even recent judgment of 2025 I have given, my lord. Then rules of the game cannot be changed, altered midway, my lord. The question
is also to 31 judgments.
The normal, I have reduced it to 51, 15, 15. And my friend has given the exhaustive one. I have asked them to give the short one. They have given the exhaustive one, my lord. I have reduced it.
Creating unnecessary burden on the court. Assistance needs to make it easier, not to make it,
No, my lord. I have only given now. I'm unfortunately sometimes communication gap, and they have in their hand and they give it the lengthy one, my lord. That is, your lordship has the short one, your lordship. Your lordship will see first proposition. I'll just take your lordship to the proposition and the relevant paragraphs I have already stated in my note, my lord. Prisoner having participated is stopped from challenging, my lord. I have given 6 judgments. Relevant paragraphs are there, my lord. I'll take one judgment only that will be leading.
Why do you say rules of the game can be altered midway?
Because rules of the game is, my lord, that it was advertised that the reservation will be for 2 posts per other backward class.
This proposition applies only if you are the person who changed the rules, not the person asking for the rules to be changed.
No, because he is asking the rules to be changed. His prayer is that I set aside the examination, set aside the result.
Okay, which paragraph? Let's see if it applies or not.
Yes, so then, my lord, what I just see the prayer, my lord, for sake of convenience, my lord, what is his prayer? Without prayer, if he says, my lord, page 22, your lordship will have page 22 of the writ petition.
Yes.
And first he questions in small Roman 1 the policy, my lord. Second, issue calling upon the respondent to show cause as to why final result of the Meghalaya Civil Services should not be set aside, why prisoner should not be appointed. Third is, my lord, direct state to provide after hearing the parties to be pleased to set aside reservation policy of 5% and should be collective direct state government to provide scheduled caste exclusive reservation and for pleased to set aside the final result. So his prayer is, direction is that set aside the result. Now, your lordship have seen the fact. Fact is that advertisement was issued on 11/2/2022. The advertisement on 28, the corrigendum expressly, my lord, your lordship have page 39 of the page 39. The advertisement, my lord. 28th August 2023.
Yes.
Name of the post, your lordship has table, number of vacancies, unreserved 5, Khasi Jaintia 14, Garo 14, OST, OBC 2, total. Now,
where's the results? Let's see.
Yes, your lordship will see page 39.
No, the results.
Results,
final
lord,
results 52, my lord.
Results is there in page 52-53.
Okay. Now where's the quota? That means 5%.
Quota I have already shown.
Who has taken this
serial number 29 and 31.
This is Coach and Raba.
Yes.
Okay.
So therefore, my lord, the point which your lordship, the question which your lordship has posed, I must answer is that the petitioner knew that 2 posts are reserved. Now the rules are already in place. That reservation has to be provided in this way. Advertisement clearly said, and thereafter, after having participated and failed to secure the selection, now he's saying that change the rules, set aside the appointment. Your lordships kindly notice the original advertisement of 11/2/22 as well revised advertisement expressly stipulated that reservation for selection process would be at par with reservation policy of state of Meghalaya. Further, the list of posts and roster provided in advertisement reiterated that category wise. Now he says that change the rules, my lord, after the selection is over, after he has participated and set aside the entire selection process, my lord. So that my lord, he has to cross the threshold. He has to cross the threshold of saying that, and he has not crossed the threshold, my lord. He is hit by the principle of estoppel, my lord. Secondly, he's also hit by the principle that rules of the game cannot be altered, and he is trying to set aside the process which is already concluded and appointments have been made, my lord.
Well, there's no question of setting aside the selection.
No, he's asking for, my lord, your lordship may not.
He can ask for the moon. Doesn't mean he can.
He can ask for. So whether he can ask for the moon and he can challenge the policy or rules which were in place when the advertisement was issued, my lord, after he has failed, my lord, law says no, you can't do it, my lord. I have given 5 judgments on this issue. I can Anupal Singh, my lord, I can cite 1 judgment, my lord, of any all these judgments with relevant paragraphs.
Yes.
So, my lord, if I only one judgment, my lord, I will place one judgment on this issue. A lordship may have the Anupal Singh, my lord, the irrelevant paragraph. A lordship will have this judgment of state of UP versus Karunesh Kumar, 2022 SEC online SC 1706. And para 21.
Para 21.
Yes. A candidate who has participated, your lordship has the paragraph 21, your lord?
Yes.
A candidate who has participated in the selection process adopted under 2015 rules is stopped and has acquisced himself for questioning it thereafter, as held by this court in the case of Anupal Singh. 55. Having participated in interview, the private respondent cannot challenge the office memorandum dated 12th October 2024, 14 and selection. On behalf of the appellant, it was contended that after the revised notification dated 12/10/2014, the private respondent participated in the interview without protest, and only after result was announced and finding that they were not selected, the private respondent chose to challenge the revised notification of 12/10/2014, and the private respondents are stopped from challenging the selection process. It is a settled law that person having consciously participated in the interview cannot turn around and challenge the selection process. 56. Observing that result of the interview cannot be challenged by a candidate who has participated in the interview, has taken the challenge and gets selected, and the state ultimately finds place in these judgments, my lord. These are the series of reference which has been made in this judgment, my lord. I will not multiply.
Appropriate also is here. The same judgment.
Yes,
judgment.
Yes, same judgment, my lord. So, my lord, the principle. So, this judgment, my lord, I need not trouble your lordship with all the principle of law is very clear.
That this is a settled law. I mean, it's
settled law. So, and after settled law, also I put a question to myself: why do we file a petition of this nature to vex the court and vex the other side? If it is law is settled, at least because I have to. Your lordship is troubled. I am troubled. Everybody is troubled. They have right to file. But settled law also they challenge it. That is the beauty of the petition, my lord. And then, my lord. The third, my lord, is that, so your lordship, I will not petitioner having participated in stop, my lord. Your lordship has seen the leading judgment. Then rules of the game, my lord. This is also a recent judgment of Supreme Court, my lord, Tej Prakash Pathak. And that your lordship will find, paragraph 13. Tej 13, 14, my lord. Paragraph 13, Tej Prasad. And this is also probably Constitution bench judgment, if I'm not wrong. Yes, Constitution bench judgment, my lord. This is a Constitution bench judgment, and I straight away lordship will have paragraph 13.
Which one? Page.
Paragraph 13, my lord.
Yes.
13, your lordship, public services broadly, scope of the reference. Public services broadly fall into two categories. One, where services are in the connection with the affairs of state or union. Second, where services are under the instrumentality of state. In either law governing recruitment must conform to the overarching principles enshrined in Article 14 and 16 of the Constitution. 14. In the various judicial pronouncements, law governing recruitment of public services has been colloquially termed as rules of the game. The game is the process of selection and appointment. Courts have consistently frowned upon tinkering with the rules of the game once recruitment process commences. This has crystallized into oft-quoted legal phrase, rules of the game must not be changed midway or after the game has been played. Broadly speaking, these rules fall in two categories. One which prescribes the eligibility criteria, essential qualification of candidates seeking employment, and other which stipulates the method and manner of making the selection from amongst the eligible candidates. Cut-off date with reference to which eligibility has to be determined is the date appointed by the relevant service rules. Where no such cut date is provided in these rules, then it will be date appointed in the advertisement inviting. And if there is no such date appointment, then the eligibility criteria shall be applied by reference to the last date appointed by which applications were to be received. 16, my lord. The law is settled after the commencement of recruitment process. The eligibility criteria is not to be altered because candidates, even if eligible under the altered criteria, might not apply by the last date under the belief that they are not eligible as per advertisement criteria. Such alteration changes therefore deprives a person of guarantee of equality opportunity in matters of public employment provided by Article 16. The reference order therefore acknowledges this legal position and in clear terms accept that rules of the game cannot be changed after commencement of recruitment process insofar as eligibility criteria is concerned. I will pause here for a moment, my lord. Once the advertisement was issued in 2022, the candidate on 11/2/2022, the petitioner knew that these are the rules of the game. This is the way the process will be played. When the corrigendum was issued on 28th August 2023, he knew that these are the rules of the game on which it is based, my lord. So therefore, to say suddenly and turn around that I want to challenge the reservation policy, he could have very well challenged those reservation policy in 23 itself when the advertisement was issued saying that it is violating without, and that time he could have challenged, not now when everything is over, my lord. That is the clear bar in law, my lord. And your lordship will have 23 and 24 also, my lord.
Yes.
Basis of the doctrine. Because your lordships keep getting the matters of this nature in our court also, my lord. Therefore, I am placing this paragraph. The doctrine prescribing changes of rules midway through the game or after the game is played is projected on rule against arbitrariness enshrined in Article 14 of the Constitution. Article 16 is only an instance of application of concept of equality enshrined in 14. In other words, Article 14 is the genus while Article 16 is specie. Article 16 gives effect to the concept of equality in all matters relating to public employment. These two articles strike at arbitrariness in the state action and ensure fairness and equality of treatment. They require the state action must be based on valid relevant principles alike, while all similarly situated and not to be guided by extraneous or irrelevant consideration. In all its action, state is bound to act fairly in transparent manner. This is an elementary requirement of guarantee against arbitrary state action, Article 14. A deprivation of entitlement of private citizen and private business must be proportional to requirement of ground of public interest. And then, my lord, the paragraph is 24. The principle of fairness in action requires public authority to be held accountable, representative, good administration requires public authority to act, and so on. So therefore, my lord, Constitution bench has settled this matter. That once the rule of the game has begun, it cannot be altered. Rule of the game was set out on 11 February 2022 and 28 August 2023, my lord, that this is the reservation policy which is going to apply. And your lordship will have paragraph 26 also, my lord, because there is a question of legitimate expectation which has been raised, my lord. However, the doctrine of legitimate expectation does not impede or hinder the power of public authorities to lay down a policy or withdraw it. Public authority has the discretion to exercise the full range of choices available within the executive power. Public authority often has to take consideration diverse factors, concern and interests before arriving at a particular policy decision. The courts are generally cautious in interfering with the bona fide decision of public authorities, which denies legitimate expectation provided such decision is taken in larger public interest. Thus, public interest serves as a limitation on which application of doctrine of legitimate expectation, my lord. So therefore, my lord, even the ground of legitimate expectation is not there, my lord. Now, third principle in my note, my lord, if you also will have my note once again, third principle is that the approbate and reprobate is impermissible, my lord. You want reservation, but you want reservation exclusively for scheduled tribe, my lord. That scheduled caste, my lord, sorry, scheduled caste, my lord. So this is the law which is well settled. And I need not trouble with your lordship. I have given the relevant paragraphs. Your lordship may have a look, but the principle is well settled, my lord. Now, third proposition is, my lord, Article 15.4 and 16.4 are enabling. Mandamus not maintainable. My lord, kindly see this judgment of Mukesh Kumar And this is the citation is 2022 3 SCC 1 page 20 paragraph 12, my lord. Paragraph 12. 2022 3 SCC page 1 paragraph 12, my lord. Para 12.
Yes.
Article 16(4) and 16(4) capital A do not confer fundamental right to claim reservation in promotion. By relying upon earlier judgment of this court, it was held in Ajit Singh 2 that Article 16(4) and 16(4) capital A are in the nature of enabling provisions, vesting a discretion on the state government to consider providing reservation if circumstances so warrant. It is settled law that the state government cannot be directed to provide reservation for appointment in public post. Kindly mark this line because petitioner is seeking direction to provide reservation exclusively for scheduled caste. Similarly, the state is not bound to make reservation for scheduled caste and scheduled tribe in matters of promotion. However, if they wish to exercise the discretion and make such provision, the state has to collect quantifiable data showing inadequacy of representation of that class in public service. If the decision of the state government to provide reservation in promotion challenge state concerns shall have to place before court a requisite quantifiable data satisfied. This is in respect of promotion, my lord. Now, 13. Article 16(4) and 16(4)A empowers the state to make reservation in matters of appointment and promotion in favor of scheduled caste and scheduled tribe. If in the opinion of state, they are not adequately represented in the service of state. It is for the state to government to decide, my lord. Kindly mark that state government to decide whether reservations are required in the matter of appointment or promotion to public post. Language of clause 4 and 4 capital A is clear, according to which inadequacy of representation matter within the subjective satisfaction of the state can form its own opinion on the basis of material it has in possession, or it may gather such material through commission, committee, persons, or authority. All that is required, there must be some material on the basis of which opinion is formed. Court should allow due reference to the opinion of state, which does not mean that opinion form is beyond judicial scrutiny altogether. The scope of reach and judicial in matters within the subjective satisfaction of executive are extensively stated in barium chemicals, which need not iterate. The issue which your lordship, the petitioner is saying that no, the policy is bad because it is hit by Article 16(4) and 16(4)A. Not in so many words, no pleading in the writ petition, nothing, my lord. But the lordship has seen consistent view taken by lordship and by the Honorable Supreme Court is that these are the policy choice, these are the enabling clause. Mandamus cannot be issued to provide the revision in one particular manner, my lord. My lord, I have cited 4 judgments, and Gulshan is also is referred to in this very judgment, my lord. The second judgment, I'll
come to the last point that the determination of reservation exclusive domain of the state.
Yes, my lord. This is
which judgments that that's only Devinder Singh, the leading judgment.
Leading judgment, my lord. And if lordship has seen that Devinder Singh, and in Gulshan also, my lord, in paragraph 16, it is same provision. In Gulshan is also there, but if lordship will see, that is quoted here also. I have seen it, but I'm missing the
right then. Yes, Mr.
Yes. And then my lord, last point is Sangmar, and those judgments are there. So the entire case is this, my lord. So therefore, the case is well settled, my lord. It may not require reference or issuance, and principle of law is also cleared, my lord. Idea is also clear. Logic is also very clear.
Well, I was under the impression that we were only to discuss the question of maintainability and whether your lordship should retain this or refer it. Now, I believe the state has argued the entire matter. I have not really had a chance to argue on merits. So, my lords, may keep it tomorrow. I'll argue on merit. So that means your lordships will retain it.
Retain it, but
lordship. So now I'll argue on merit tomorrow, my lord.
It's up to the court master where he can have it tomorrow.
Lordship.
You kindly sign the document if you pass on to the court. Sorry, Mr.
Lordship.
Mr. Sen.
As per any earliest date, my lord, convenient to your lordship.
It's just a matter of further hearing or something.
Lordship.
He'll give the date.
Obligement.
Because the Devendra Singh judgment was much awaited in the context of the reservation.
The passages that are referred to by the Sikh, they're actually in my favor.
Classification like scheduled tribes, whether you can make 40-40. So that is.
Lordship. In fact, Davinder Singh has passages which are in my favor. I'll point that out. Obliged.
He has to cross the hurdle of estoppel and all those police. Then only the legal question would arise.
Very interesting, yes.
But please, Lordship. Lordship, actually, this matter actually went to the mediation. Now, what happened actually in the mediator during the mediation? Government have said something. No, the government says that they will provide the matter to the financial department, but then the mediator says since within 90 days they have to list the matter before the court. So maybe they have taken the document also. Yes.
In fact, on the last day of the mediation, the petitioners didn't turn up.
No, I was there.
No, we were there. This was listed again.
Listed again. I appeared, and the mediation says since they have come all the way from receive Belpara. The second time, mediator say you no need to come. Only your counsel can come. That was the statement. So with the permission of the.
Lord, in my presence, they called me. No one picked up the call. Neither anyone turned up.
No, that is.
They also.
No, I was there. On the first occasion, we come. Then
the second time, it didn't come.
Second time, mediator since he's very but the difficulty is there since you don't need to come. Only council can represent. So we come.
No, that's not the case.
Then at that time they said the government will provide the matter. Then they have even taken the repetition want to provide the matter.
They will hear it. Yes.
Yes.
When the matter was taken up for hearing.
Doesn't matter now. If it has come to that stage, then we can, instead of mediation, we can dispose of direction.
Yes. Now only the matter here left is that the disease is the petitioner here is the daughter of the deceased employee. Now
all gratuity benefits.
Yes, all the benefit has been given. Now they are saying that the regularization and confirmation is not done by the personal department. That was the only. That is they're denied. That is the only thing that is. On the last occasion, my lord, can you see the order dated 12/6/2026 also, my lord, where Lord Chief has given some observation. They are supposed to get an instruction. This is stated that may I just read it?
Department, no doubt the irregularities are there, my lord. Undoubtedly, some money has been cleared. Only thing is that, my lord, without the.
So they said they will rectify
approval of the finance department.
See, 12/6, what happens is that, it's recorded that.
Yes, my lord.
What is clearing, however, the writ petitioner has already drawn the leave encashment and GPF for this employee who is a mother. What remains only gratuity amount?
Yes, my lord.
Yes. That was a very small amount, only 3,40,000.
Small amount here, 40,000.
3,40,000 only remaining.
That's a huge amount.
Yes. Well, without the concurrence of the approval of the finance department.
No, I mean, like, we can dispose of with directions that you consider.
Yes,
see, the thing is that
only difficulty
you already paid a company. Now you already paid is not a question of not even one terminal benefit being allowed, correct?
Yes.
So you already given even cash, you already given the GPF. What remains now?
Yes.
So take instructions.
Yes, my lord.
Yes.
Otherwise, my lord,
this court by order 12/6/26 had observed as follows. Quote, as it appears that only the gratuity remains to be paid to the petitioner who is the daughter of the deceased employee, Mr. Kibu Shaji, then a GA prays him out to obtain necessary instructions. Just after 3 weeks, yes. Whatever 12/6. That will be just one step for mediation.
38.
Lordship, this is the cover case when the last occasion my lord has passed an order dated 21/08/2026. Very similar situated case, same cases, the same everything. All this one is my family. Because even the petitioner name also is reflected, the cabinet memorandum, everything is the same, my lord. So, therefore, this matter also can be disposed of.
Yes, Mr.
No, the question is whether the petitioner's name is forwarded or not. I'm not aware.
It is there. My name is very much there in the kindly see the rejoinder there, page 28. The page 28, the page 29, the relevant. My name is appear in the serial number 7, my lord. This is the same petition, the same similar situation, same facts of the case. Everything is there. On the last
in our affidavit, we have stated that he falls short of the qualifying service.
Qualifying on the
how many days?
One of
see, in that petitioner was appointed in the year of 1990.
Para 11, my lord, we have stated.
1 second. Where rejoinder? Where's the name?
My rejoinder, kindly see the page 29. Rejoinder page 29. Rejoinder petition. I have enclosed the cabinet memorandum also. Actually, the page 29.
Okay,
my lord. Kindly see the
serial number.
Serial number 7.
District.
It's a Rishubel Para.
Number 7.
Number 7, my lord.
He was appointed in
1990.
1990.
Yes, but in that petition, other there. Yes, I'm even senior than those people with those petitioner which have already been disposed of. They have. Moreover, I served more than 33 years. 33 years, counting from the date of the appointment. 33 years. Retired. I was retired on 31/10/2023. Worked more than 33 years. And those petitions where Lordship has considered, they were appointed in 1991, 1993, and 1992. However, I was appointed prior to them only. So this is the fact, and I have also enclosed the judgment where also in the repetition.
How many cases are here? Only one.
Para
this
11.
is only one. Actually, this is the only one.
Lord, para 11, we have stated that his service falls. Nevertheless, my lord, at least let me find out whether his name is also forwarded.
It is there.
It's there
Already. We have given the.
This is the list.
One thing. You give a copy. Mr. Salma.
It is there too.
No need to coach him inside the courtroom.
No, Lordship. Because he said
you give the copy of the order.
Yes.
Then you show that it's the same. Then you show that it's hard. Yes, we'll take it up day after tomorrow.
Yes.
As Mr. P.T. Sharma submits that the matter is squarely covered by the judgment of this court rendered in WC number 403/2025 and other connected matters. Mr. Q is to examine the same just day after tomorrow.
I have given the judgment also. Much obliged, Lordship.
Please, Your Lordship. Lordship, on the last occasion, my friend had submitted that the petitioner had not been receiving salary for a couple of months. Now it appears that they have received the salary, Your Lordship. There was some miscommunication due to the change of
pension.
No, this is work charged employee, Your Lordship. He is a work charged employee appointed in the year 2000 after the ban of work charged employees, and now he seeks regularization, Your Lordship.
My lord, the last occasion on
where is it
1/4/26, my lord.
Where is recorded you not receiving?
Well, on 1/4/26, an order was passed asking the government to take instruction on a letter which was sent by the PWD department to the government that those who were appointed after 27/10/97.
So which order is this?
This is on
it is 01426. 1/4/26.
It's 4th June 2026, Your Lordship. He had said about the not receiving the salary.
No, 1/4 is okay.
1/4/26.
Yes, 1/4/26.
Oh, I don't have that order.
It is later dated 11/9/26, page 32, my lord.
Annex your affidavit.
Yes, in their affidavit, my lord. That they had sent a letter to the government.
No, the thing is that, see, which Section 7, what does it say? There's been no clarity regarding the fate of the letter dated 11/09/2023. Section 7.
Your Lordship, what has happened is that, Your Lordship, I have been instructed that names have been forwarded. The different divisions and the departments had been asked to give a detailed compilation of the names of all the work charged employees who had been appointed after October 1997. And now according to my instructions, about 349 names have been forwarded to the government, Your Lordship.
What's the outcome?
And the outcome is, it has just been forwarded because they were waiting for details from all the divisions and departments.
May I add, my lord, to what learned double AG has said, my lord. We have because this issue is pending before the division bench also, my lord, in one of the matters. So division bench has asked the government to consider the entire aspect. We have collected about 1,300 of them are work charge implies, and then we have categorized those work charge implies in different categories because some of them are recently engaged. Some of them are recently engaged. Some of them are engaged 20 years
Long
back.
time ago.
Some of them are long time ago. Some of them are engaged against the policy decision of the Lordship has dealt in one of the matters, my lord. So we are grappling with this situation. In fact, 15 days back also there was a high power meeting. I was also, and then we are trying to see how it can be done, whether work charge, because they are charged to the establishment only, my lord. And their establishment work is over, then what I'm informed, my lord, that what if road work is over, then they are employed in the office. Then their third work is, so there is some kind of problem which the government is facing in.
This person has been appointed since 2000.
Yes.
26.
Yes, my lord. There are cases. Probably these cases will be addressed, my lord. We have.
So it's under examination, actually.
How many
those who have been.
My instructions were 349 numbers, but now the AG says about 1,300.
About 1,300.
1,300.
Yes, when the matters are being heard,
Mine is from the PW department.
Similar such matters being actively considered by being
examined
and considered being
by the government,
by the state respondents. And this will be the matter listed after when?
After 4 weeks, my lord.
After 4 weeks, yes. Are you getting a salary?
Yes.
He's getting a salary.
41.
Obliged.
Yes.
May I please, Your Lordship?
This is that matter, my lords, of pension, my lords, in respect of the second wife. On the last occasion, my lords had partially, my lords, heard this matter, and the question arose. Clarification, my lords, was sought by the Honorable Court in respect of which rules will be applicable. Because if your lordships recollect, that in this matter what happened is that the person concerned, the petitioner, had retired in the year 2004. As on the date of his retirement, the notification, the rules, Meghalaya pension rules, provided that the wife after retirement would not be entitled to pension as on 2004. These rules underwent a change in the year 2010. And in the year 2010, the rules provided that the second wife after retirement can also be entitled to family pension. The question here is about family pension.
Not only question whether she'll be entitled or not, that's all. Yes.
That's the question, and the rules provided that these rules of 2010 will have a retrospective effect from the year 2007. So this is as far as the rules is concerned, my lords. What happened with the petitioner is that in the year 2009, he claims to have underwent a second marriage, which was registered in 2011. That is, my lords, there as far as his second marriage is concerned. His first representation of changing the pension payment order was rejected in the year 2009 itself. That was never challenged and has not been challenged till date. Thereafter, my lord, subsequent representations were also rejected in the year 2016. That representation, determination of that representation has never been challenged, is also not under challenge in the present petition, my lords. Now, in the year 2016, the petitioner died. The petitioner is now no more, my lords. And
now after how many years? 25.
My lords, yes, my lords. So 2025, from the date of first representation, my lords,
it is 21 years. It is, my lords, it is 26 years. From the date of retirement, my lords, it is 21 years, and from the date of rejection of the first representation, it is, my lords, 17 years.
So, Mr. Chaudhary,
2004 to 2025, 21 years.
I think you take instructions. You tell your client, otherwise we will dismiss your petition.
Your Lordship, when my right,
question of delay only.
No, when my right has been accrued, actually, I have explained, my Lord. This is in my petition very clear, because
even then on merits also, I don't think you have a case.
The thing is that, my Lord, this pension is a continuous right, my Lord.
No, we have not challenged the earlier when it was denied in 2000 and.
No, 2009 actually it is not on not in my knowledge, my Lord.
Then
because
it continues cause action means not in your knowledge, you should have known.
No, thing is that when my husband has been expired, actually since that time in 2017, when I wrote to the department concerned, one RTA has been filed. Then only they have replied in 2017. Thereafter, I came to before this court.
When do you file this case?
This first I filed the writ petition in 2022, my Lord. This is the third writ petition. And they are avoiding one by one, Your Lordship. And in my first writ petition, I have explained in reasonable explanation I have been given, and it has been admitted accordingly. This is the third writ petition, my Lord.
See, now the Fifth Amendment of 2010.
Yes, ma'am.
Now your only claim is that you're married, but your marriage registered in 2011, correct?
2009, ma'am. Or 2011 with an effect from...
Yeah, but then 2009 there's no tangible evidence to show anything 2009. These rules came to effect from 2007.
2007, yes.
Yes. So,
this effect from 2007, my Lord. And my Lord, this is a very reliable judgment also of this Honorable Court already passed in Jamshed Ali, Your Lordship. This is a covered case, my Lord.
Jamshed Ali,
yes,
see the judgment.
By this this is in 2024, my Lord. So same objection has been raised, my Lord, in reference in the context of Honorable Supreme Court.
Have you seen the judgment? I have not seen it.
Huh?
Well, I have seen the judgment. In Jamshed Ali, the petitioner was alive. The main person concerned who was seeking the modification of the pension payment order was alive. In this case, that person has died 10 years back. And my lords, as your lordship noted in the other matter, my lords, as per Rule 53, there has to be a joint photograph of the petitioner and the wife concerned, which has to be affixed, and he has to verify that she is my wife. All of that cannot be done, my lords, undertaken now after 10 years of his death. And secondly, my lords, there is another judgment of this honorable court, passed by this honorable court, and then, my lords, reaffirmed in the division bench of Anandita Bhaumik, which categorically says, my lords, that the new pension rules of 2010 would not apply to any person who has retired prior to 2007.
Oh yes, I remember the judgment. Where's the judgment, Anita Bhaumik here?
My
learned friend must be carrying that. Anita Bhaumik?
It is not a claim, my Lord. And he has not referred actually this one earlier.
Yellow will give that a chance. You kindly.
This is writ appeal number 8 of 2022, decided on 4th of April 2022 by Milot's division bench, affirming Milot's the judgment passed by this honorable court.
You can provide a citation later. Yes, we'll have up to 1 week. You prepare.
Yes, Milot.
Otherwise, very bleak.
I'll prepare.
The request of Mr. N. Chaudhary, it is up to 1 week for the hearing.
What the case number is?
Push 2.
Obliging.
Please, your lordship. Your Lordship, the petitioner has approached this Honourable Court, my Lord, to seek pension, my Lord, as her deceased husband, my Lord. She's a second wife, no doubt, my Lord. The first wife have already expired, my Lord, and she had filed representation before the respondents, my Lord, to grant her.
Figure about 2 o'clock then, 2:15.
My Lord, my Lord.
Next week, Lord.
My Lord, she is.
Expired 2012.
He expired, yes, my Lord. The petitioner's husband expired in 2012, my Lord.
You're drawing pension after that.
My Lord, after 2012, she's not getting any pension, my Lord.
No, he died 2012. You're not going to. Are you a legally married wife? You're the
My
first
Lord,
wife, second wife.
I am the second wife. My Lord, I'm not legally married. I was living with him, my Lord, since the year 1990, my Lord.
Now,
and I have got one child, my Lord.
The child is how old now?
Now the child is 20. Major. She's a major, my Lord. And further, my Lord, the petitioner is 75 years of age, my Lord. Now, and she's running from pillar to post, my Lord, just to get her pension, my Lord, pensionary benefits, my Lord. And my case,
She's not a legally married second
my
wife
Lord,
also.
my Lord, but I have a child, my Lord, and therefore, my Lord.
Your child is already 23 years old.
And further, my Lord, there is this at Annexure 4, my Lord, page 12. The Rangbachnong also knows that we are residing together, my Lord. My Lord, and my case squarely cover under this judgment of this Honourable Court itself, my Lord. I'll just. My Lord, the relevant para is para 10 and 11, my Lord.
No, but a factor of marriage is there or not?
My Lord, we were married. He was living with me, my Lord, and he expired also.
Case in this court, this first wife, second wife, third wife.
My Lord, but my Lord, if the first wife is still alive, my Lord, yes, my Lord, but my Lord, the first wife also expired. She expired. That is evident from his service book. From
the death certificate.
My Lord, the death certificate, I don't have it, my Lord. The petitioner does not have it, my Lord, but kindly come to page number 21, my Lord, of my annexure, page 21, my Lord.
Yes.
Wherein if you kindly see, my Lord,
He was
page
appointed in 63.
My Lord, it's reflected here.
He died in 1995.
His first wife.
Not 1995. He retired on 2000, Lordship.
No. This what 21 documents this?
Yes, Lordship. But as per the
what documents this?
My Lord, actually, my Lord.
Who documents this?
My Lord, this is a part of the records which have been provided from the petitioner.
Who is this person? You are a teacher.
My Lord, the teacher is his wife. By profession, she was the teacher. Late Mavis Bun Nongter was his wife. So she expired, my Lord, on 07/11/1995, my Lord.
And married you on in?
In 1990, my Lord. I was married to him in 1990.
But she died in 1995.
Yes, my Lord. If she died, if the first wife died, the second widow is entitled.
No, I mean she died. He married you while she was alive.
My Lord, my Lord, that aspect, my Lord, when I confronted.
And you say 1990 he married and then she died. So then, and this is reflected in the pension papers of the AG. So, and he is taking her family pension. See.
Yes, my Lord. He is taking the family pension, my Lord. However,
and at the same time married to you.
My lords, they were also not living together. They were already separated by that time, my Lord.
This compulsory registration marriage is absolutely necessary. There should be some awareness, I think.
Yes,
when contracting second marriage, either way or cohabiting, must register in some way. Otherwise,
my Lord, he was separated with his first wife. Then after that, my Lord, he had resided with his second wife. Then out of which one child was born.
Apart from the Rangbachnong certificate.
Apart from the Rangbachnong certificate, my Lord, we reside together, and I have a birth certificate of my child, my Lord. Birth certificate of my child is annexed here also, my Lord. My Lord, kindly come to annexure 3, my Lord. Birth certificate of my child.
The certificate in 2025. You say 1990, Rangbachnong says 1991. Anyway,
My lord, kindly grant pension to the petitioner, my lord. She is 75
Yes,
years of
Mr.
age.
My lord, this is the what I believe. This is the PPO belonging to the first wife of the.
yes, he's drawing funny pension of the first
Yes, she
wife.
was drawing.
Yes.
Yes, that is. But as per my document, lordship, but she is claiming that she was married 1990, lordship. Now there is a document which I have annexed. The details of family members are given, lordship. If she was married in 1990 and by the time or 95, as per her submission that the first wife died, obviously the name of the petitioner would have been reflected in my document, the Annexure 1, lordship.
Next one.
Yes. Page 4.
Yes, lordship. Page 4 and 5, lordship. The date of the family details are there, lordship. These are the son and daughter of the deceased, lordship. Her name did not figure. What she is saying that
given on,
my lord, below is the date, lordship. 4/5/2000, lordship. And he retired on 31st/3/2000, lordship. And this is one aspect, lordship.
have you counted this?
My lord, I have not filed a
Cannot count it
region.
also difficult.
Yes, my lord.
And annexure, next annexure, lordship, that is a document of 1992, lordship. As on the details of the family member as on 1/1/1992, lordship. That is all here also the name of the first wife reflected,
Mr.
lordship.
shown is 92.
Yes. Now
You won't show second wife.
Now
It
that
is-
is what I am
But
submitting.
then
lordship.
even if you say that 1990
Yes.
separated, now why are you showing the name of the first wife here in this details?
Even her name would have been appeared in the Annexure 1, lordship. That is the document of 2000, lordship. And by the time the first wife has already died, lordship.
My lord, my only humble submission to that aspect, what my learned senior has stated, my lord, is that, my lord, if the first wife had expired, my lord, she has expired, so the second wife can get the pensionary benefits.
But
my
you're
lord.
not, there's nowhere, nothing to show that you ever married except from the
My
birth
lords,
certificate.
my lords, I have my birth certificate of my child. We were staying together, my lord, and we did not marry in the church or the
Anyway, forget that. I mean, where's the birth certificate?
My lord, the birth certificate is at annexure. At annexure page. My lord.
Rupsi.
And her epic also does not reflect the name of her husband.
Yes.
My lord, it's
Where's the
birth certificate and page 11 annexure 3, my lord.
death certificate doesn't show name of the wife?
Even her epic also.
Yes.
Epic has
page 10. Where's your name?
Yes, my lord. My name is not there. It's blank. It's written, my lord.
No document to show that she is the wife.
But my lord,
She might be equal, but then like
I have
they
the
have
birth
to go
certificate of the child.
She can't substantiate it. Yes.
My lord, I have the birth certificate of the child, my lord, which I've born.
What's his name? Reynold Rupsi.
Yes, my lord.
Registration by court order.
Yes, my lord.
2007.
Yes.
After he died. He died when?
He died in 2012, my lord, before he
He was
expired.
still
yes.
alive.
Yes, he was still alive.
Very difficult. I know it's a legal aid matter, but
Yes, my lord. My lord, on the last occasion, on the mediation also, they have asked for the marriage certificate, my lord. But hence, we were already married. We have only the birth certificate and the Rangpachnang certificate.
There is no any document to substantiate her claim.
Where's
That
the
is
epic card?
that is the
My lord,
difficulty, lordship, of the
epic card.
department also.
Epic card is
Annexed
an extra one, my lord.
But that also does not show the name of her husband. That is the difficulty, lordship. No, there is any document.
that is the problem. We can understand her difficulty, you know. It happens many times, but then very difficult. How will the court order? We can't order in the air.
I understand, lordship. If that child was minor, then at least
Yes.
she would have got the benefit.
Now she's born 93.
Yes, my lord.
She's major now, 1st July
She's
1993.
major now. Yes, my lord.
32.
What to do? Sorry, 130. Yes.
My lords, my only humble prayer is
Whatever prayer you make, but very difficult to exceed. I don't think any other case also that's similar to this.
my lord, there is no fact, there's no, there is no dispute to our living together, my lord. Of course, we have not got married, my lord, in the church, but then.
No, I understand that. Even then. Whether, see, for the purposes of second wife, there has to be some tangible that they were, she didn't tell. Now, even that one given to the daughter, you're not open to that anymore.
My lords, I may be allowed.
She's 5 years old.
She is 75 years old now, my lord. She can barely walk. Also,
Her
my
daughter's
lord.
there,
Her daughter is there, my lord.
not helping her.
My lord, she's also unemployed and having some financial crunch, my lord. So for that reason, my lord.
No, next
kindly-
quarter then. Posted after this 1 week. Try to come up with something.
My lords, my lords.
Master.
Obliged, my lord.
Let it be after 2 weeks, lordship.
Otherwise,
44.
Master.
ready the matter?
Yes, your lordship.
We'll have it after lunch.
In this matter, substantial question of law has not been formulated
Yet.
No, my lord.
Why?
So, my lord, if my lord permits me to suggest the question, my lord.
This is a Mr. Appeal second only. What
Yes.
substantial questions of law are there?
I've suggested 4.
Let's see. Yes, I think this first question is quite.
My lord, if my friend wanted to suggest some questions also in place, your lord.
Your lordship, the learned lower appellate court, your lordship, had reversed the.
They'd reversed, yes.
Your lordship, on the ground that the trial court had not observed the triple test in granting injunction, your lordship.
But whatever it is, he never played for injunction also.
Yes, your lordship.
It would have been rejected.
Reversion.
Not that that you grant relief.
Yes, your lordship.
That's the only thing.
Your lordship, the reversion is on the after the reversion.
He should have reverted back to the trial court.
Yes.
If the injunction was granted, on
In fact, it has
whatever
not gone into the
considerations that the appellate court found that yes, it's not sustainable, you should have just set aside that order.
Your lordship, because the trial court in granting the injunction, your lordship, the triple test had not been observed.
Forget trial court. Trial court orders over. It came for the appellate court. Appellate set it aside. Correct. But appellate court itself granted relief to you.
Your lordship,
right?
on the ground that substantial injury was suffered by me, your lordship. That's why.
Yeah, but did you make out a case? Did you file for
Yes, your
injunction
lordship.
also for the appellate
And
court?
the impugn order, your lordship, a reason or judgment was.
From your side.
Your lordship, have shown the because it involves the dilapidated school, your lordship.
You can't go on emotions, especially in civil matters.
Your
You
lordship.
have to go strictly according to procedure and law, and whether the court has exceeded jurisdiction.
Your lordship, moreover, I'm also in possession, your lordship. The trial court had failed to see that, your lordship. I'm
That
in
should have
possession,
gone back
your
to the
lordship.
trial court then.
Yeah.
If you're in possession, there's no question of injunction being granted against you. They can only file for eviction. They can't ask for injunction.
Your lordship.
Injunction was granted to them even you were in possession of the suit land. Injunction was granted to them.
Yes, Your Lordship.
Is that the case?
Yes, Your Lordship.
Injunction was not
They
granted.
will dispute that. Now they'll say you're in possession. Who's in possession?
I am in possession,
We
Your
are
Lordship.
claim both in possession.
No, Your Lordship. There's
This is a case of
an order by the
encroachment.
executive magistrate, Your Lordship, that
We
I am
both
in
have
possession.
lands adjacent to each other, man.
I am in possession.
See,
Your
if you're in possession, there's no question injunction be granted against you. He had
Yes,
only
Your Lord.
asked for a decree for restoration of possession or for eviction.
What is
Correct?
important, my lord? Number 4. Number 4 is very important, my lord.
It's not a third party right.
So
Your Lordship,
anyway,
here. Your Lordship.
whatever it is, third party interest has been
No, Your
created.
Lordship. No, Your Lordship.
It's already created, man.
No, Your Lordship. Because I am the owner of the land, Your Lordship, and I have absolute authority in allowing the Darbar to construct the.
Then who's the Darbar? It's not you.
No,
You're not doing the construction. Now what do you mean with third party?
My lord, in their appeal,
Third party can even be a tenant in your house.
Your Lordship. However, Your Lordship, so many developmental projects from the government, I've never denied that, Your Lordship.
No,
And this,
we're not in a different jurisdiction. We're talking strictly from the terms of, suppose you have come under an order 39 applications been filed by them, injunctions been granted, correct? Against that you file and a miscellaneous appeal or first appeal against whatever this injunction order. And while setting aside the order of granting injunction, the appellate court has gone ahead to grant injunction in your favor and also allowing you to raise construction.
no, Your Lordship.
Correct. That's what he's submitting.
Yes, that's the
As a-
submission.
in the order itself, it says you can raise construction.
Yes, my lord.
Your Lordship, Your Lordship can come to the.
Yes,
can come to the impugned order, Your
No,
Lordship.
anyway, since he's, although I am not really sure whether in a
my lord, in the
miscellaneous
appeal,
first, second appeal, substantial question, let's say, but these questions are, these issues are quite important.
Your Lordship, however, Your Lordship, the condition of because Your Lordship, in the year 2009 we have
We're
instituted.
not going to the facts.
Your Lordship,
on law.
yes, Your Lordship. Your Lordship, you can just see the impugned order, Your Lordship.
Now, the only thing is that on law now, whether this order of the appellate court is sustainable on law. When you come in a second appeal, usually in the regular second appeal, then you can't plead your facts anymore.
Yes, Your Lordship.
It's only where the appellate court has heard the law.
Yes,
Right.
Your Lordship. The
So it's very,
the first
very
appellate
limited.
court had reversed
Now,
the
whether
order
this
because Your Lordship.
appellate court has exceeded jurisdiction in passing the order granting injunction, when in fact you never prayed for one.
I never prayed, Your Lordship. However,
Yeah.
Your Lordship, the reversion.
You never prayed,
it's
then reverting the injunction
it's-
order and
yes, Your
giving
Lordship.
you relief over and
It's,
above that.
It's reversion amounts to reverting back to the position where it was, Your Lordship.
Okay, reversion amounts to rejecting the injunction prayer, correct? That does not amount to when it's not pleaded or it's not there in your or any petition under 94 CPC. I think that is not there. They have granting you relief.
Your Lordship, because the settled law was not upheld, Your Lordship, because there was settled law.
Settled law is
Yes, Your
different. That's a
Lordship.
finding.
Yes, Your
Finding is fine. Finding, suppose you're sitting in appellate court, fine. I find that the three, the three principles injunction have not been fulfilled, and so the trial court has erred in the injunction. Injunction set aside. Then matter goes back. The main suit to be tried.
Not sure.
Then there you feel that if you build a house or build something, then you file a supplementary application.
Yes, Your Lordship. The question
But
is,
your
Your
case not
Lordship,
happened.
who suffer substantial injury.
Suffering?
Yes, Your Lordship.
You see, you didn't suffer. You're not. Anyway, you'll not go there. Why should I argue you? Anyway, today just though
Your Lordship,
Mr. R. Khasab, the counsel today for the appellant, has filed 4 suggested substantial questions of law for consideration by this court. Top, Mr. Malingyang.
Your Lordship, the school is in a very.
See, we can't have those kind of submissions. We are going on.
Now, since the status
the
quo
only
order
thing
is in
for you,
operation, Your
we
Lordship.
better you just look at these questions, you try to address them the next day, then we will then we will dispose of the matter.
Yeah.
Okay. Mr. Malingyang is also permitted to submit Supreme Court of Law if necessary. It's after 1 week then. Then court will just those are issues. Very interesting.
Yes.
Yes, because it's on procedure, not on anything else. Yes. Yes, absolutely. Honey. Yes.
Lord, in this case, my lord,
There's a reduction of age, my lord, from 65 to 58.
Have it next week. Yes.
it's not a case. It's not a case of
Yes.
reduction, my lord.
It's a reduction, not deduction.
Not of increases.
Yes.
No, the age was 58 all throughout, my lord. Age was 58
No
all
case you have,
throughout.
Dr. Mozika, here.
We have case, my lord.
I've seen the matter, I think. Yes.
I'll try to make out the case, my lord.
Yes,
Next
after 1 week. Yes.
49.
After 1 week, yes.
Much obliged.
I don't want to keep too many CAVs now, yes.
And lordship, there are so many matters now
Yes.
coming before your lordship.
49, your lordship, may be taken after 1 week.
Not at 2 o'clock.
After 1 week, you're not looking
1
to
week.
the- Yeah, 1 week or 2 weeks.
No urgency.
He was
Urgency
dismissed
is
from
there.
service, then because he was acquitted in the criminal case, he has filed a
He was,
representation
acquitted in the
for
criminal case.
being reinstated.
Acquitted in the criminal case.
So on that ground, he wants a reinstatement, which has also
Same
been
standards-
rejected.
Same standard is not applicable for criminal case and
Yes,
for
Your Lordship.
job proceedings. You just try to
He
make out a
was
case.
Acquitted.
Yes.
Oblige, Your Lordship.
He did today, my lord. One matter.
Yes. Even though it's beyond the scope anyway.
Yes. Obliged.